Let it appear under the heading contained in the monthly combined list. It will be taken up in the next one. Yes.
Applicant is running in monthly.
Yes. What is the urgency?
You see that she is not getting the and
Not an urgent matter. You are getting my already. Let it be there. Yes. Yes. Sorry. Hearing matter or motion?
Motion.
What was the last order passed?
2023. 2023 was 5 plus R.
2020 it was 5.
2023 it was 5.
Yes.
Therefore, Lord, faculty 5. So twice, Lord.
Why he was not getting chance?
I have taken chance because Lord, last year, Lord,
No. Why he is not getting chance to participate in the counseling?
allowed, what is the marks is there?
So that is not coming under the regular matters where petitioner was selected, but petitioner was working under SLST 2016 classes 9 and 10 or 11, 12, and that's why petitioner could not appear. That is not the case.
No.
Sorry. Yes.
Not selected.
Let it appear. It is not appearing under the heading. Let it appear.
When praying for application, the
Next month.
petitioner's father has died in harness and she applied for compassionate appointment, but not getting
Upgradation. When father died?
Well, in the year of 2014.
It's not. It will not be upgraded. Let it be there. Yes.
Malad, may I be permitted to mention one recalling application, Malad, for inclusion, Malad?
Yes. Hand over the screen.
May I permit to mention for upgradation. Item number 992. Urgency is that my lord, the petitioner PIC of a school taken charge my lord, in the month of January 2025. After taking charge, the president my lord non-cooperated with the TIC and other assistant teacher. What has happened? No record. Nothing has been given to the petitioner TIC. Now the school my lord is running without my lord any no accounts, no service record of other.
Not an urgent matter. Sorry. Yes. There may be administrative problem. Try to sort it out. Yes.
I'm paying for the accreditation, your lordship, 2 reasons. Your lordship.
Appointment is withheld. From which date?
Your lordship, the recommendation given by the School Service Commission is 14/11/2025. 12/3/2025. So what ground is that? Verification of the SC certificate. Give a notice till 20th November 2024. This is record is not proper. Issued by the respondent number 4, your lordship.
The SC civil cast certificate is questioned. Civil cast, so therefore the correctness of the civil cast certificate has to be considered. So wait for some time. It's not an urgent matter. Yes.
Well, I'm paying for upgradation.
It requires consideration full-fledged whether your SC certificate is correct or not. Yes.
Well, I'm paying for upgradation. Well, the ex-headmaster of the school has not handed over the charges to the present headmaster. Therefore, he is facing.
You are not getting giving some pension or no liability certificate. That's why.
Well, I made a represent to the DI. DI is also sitting tight.
No, it's not an urgent matter. Yes.
Called for fast-paced counseling of upper primary, but they could not appear as they were serving in SLST 27.
You mentioned this matter last week. Yes.
Matter, my lord directed me to.
No, it is hearing matter or
motion.
Motion. When you have filed it?
It was filed on 26th.
23.
2015.
Writ petition of which year?
2015.
2015.
25.
2025.
July 2025. I have
so
filed.
they were working as assistant teacher.
Mine.
Now they have lost job.
They have lost job.
Tainted or untainted?
No, untainted.
Untainted. How many candidates are there?
I have 2 candidates.
Hey, ওটা কবে আসছে লিস্টে?
Other matters are picked on tomorrow probably.
শুধু আসবে না ওগুলো কবে আসবে ফিক্স ম্যাটার গুলো? মুশকিল বলো।
Mr. Ghosh
কি না না না, যেগুলো ফিক্সড ম্যাটার অনেকগুলো আসবে এসএসসি ইয়েতে। মিস্টার সুদীপ ঘোষ চৌধুরী অ্যাপিয়ার করছে, অনেকে অ্যাপিয়ার করছে, অনেকগুলো রিট পিটিশন একসঙ্গে কালকে। কিছু হিয়ারিং আছে, কিছু মোশন আছে। হ্যাঁ হ্যাঁ, টুমরো, বা আজ 11th, ভেরি ওয়েল, টুমরো গিভ নোটিস,
But I have already served.
সার্ভ অ্যানাদার নোটিস।
But for changing the list and then getting it.
Hand over the month list of September. Let me see. Let me see. There is a
Especially events.
let me see if I can reach. It is already appearing in the list. Let me see. I cannot commit now. Yes, it is appearing on the already list in the list.
This one is not assigned matter.
Assigned when assigned?
It was assigned before vacation. One day it was taken up for hearing. And then you will start,
Is it not appearing in the list?
it is appearing in the list, ma'am. The hearing is required, ma'am, because there is a stay on the selection process of food sub-inspector.
Yes, lady advocate mentioned this matter few days ago. Let me see. Now, when it is appearing under the heading motion, let me see. Let me see. It is fairly at the top, motion. Motion will be taken up. Wait. Yes.
One contempt application, my lord.
Yes, yes. What do you want? Where your matter is appearing?
It was entered court number 551.
550, 551, yes.
You asked directly me to submit the.
What is the urgency?
The petitioner suffered severe pain. After surgical operation, he is now in
Now he is
bed.
in bed.
Total bed.
He is not attending the school.
He is retired.
Yes, retired. When retired?
In the year 30th January 2017.
70. So now he is getting pension.
Yes.
Let it be there in the list. No, no upgradation, yes.
For non-prosecution.
Hand over the slip.
And one matter for extension of
Next Monday.
one matter for extension of
When expiry?
that 31st of August. When matter was not there, Mrs. Rai extended the matter that please.
31st August.
Yes, I am covered by PHRT, sir.
29th August.
There is one matter regarding where I lost the job at upper primary, unpaid. That
So what do you want?
that to be listed.
What for?
That
For inclusion in the list?
for the
Yes, month list of September.
items 930 after cancelled not for only 3 months. Return from its service. Assistant teacher.
It is appearing in the list.
913. February 6.
You are not straightaway entitled to get pension because your length of service fell short of qualifying service. So matter has to be hard. It's not an urgent matter. Sorry, you have to wait. Yes, I may have delivered judgment, but you have to wait. It's not an urgent matter. Straightway an direction can be given. Yes.
Right, inform them for head exam. Now, for it, you can sign up teacher in charge of the school. The teacher in charge refused to sign on that application form and avoiding so many days. Now, the application form last date is 30th September. Kindly, upgrade matter
Now, when you have filed it, 2025, what was the order passed?
Next one,
So when this is appearing at which serial number?
serial number 917 for month.
This cannot be fresh matter.
Heard by your lordship.
It cannot be a fresh matter because fresh matter serial numbers ends 227. So what was the last order passed by this court?
There is no sun from.
Sorry, you have missed the bus. Yes. Please wait. Yes.
May I have your lordship kindly to mention one matter for upgradation, my lord. Matter relates with appointment of teachers in primary grade, my lord. Appointment letter was given to me, my lord. Selection was complete, my lord. Counseling complete. Appointment letter given, but difficulty is that, but within the time I failed to join. Because of the fact, my lord, my wife has given birth to two twin babies, my lord, premature babies. That was the only difficulty, my lord. Your lordship has heard this matter for 5 to 6 times, my lord. Matter is appearing under the heading motion, my lord, item number 253 of
So it
today's
is fairly at the top. It cannot be upgraded. It is fairly at the top. When motion will be taken up, your matter will be taken up. Yes.
One contempt application, madam.
It is appearing in the daily cause list. Yes.
One contempt application order was passed on December 20.
Hand over the slip. Next month.
Particular higher secondary matter has been dismissed for default on 20/2024.
What do you want?
Lordship, subsequently, your lordship will file the restoration application and your lordship heard the matter. Passed the order that the matter will appear on the constitution. However, since the matter is not appeared in the list, and it's a deleted one in the matter.
Hand over the slip. Unless until writ file comes, it cannot be included. Restoration application is to be heard.
It has been heard, your lordship.
So now what do you want? The writ petition is to be included.
Yes, your lordship.
When the matter was restored.
Your lordship, the day, can I have the slip again? That date is. Your lordship, it was restored on 28/2/2025.
So what was the direction given?
Your lordship, disclose the matter to its original position and pass an order directing that matter is to appear in the monthly list of April. However, your lordship, the matter.
দেখো তো এপ্রিলে আসেনি কেন? রেস্টোর করে ডিরেকশন ছিল। Is it a primary matter?
Higher secondary matter, but she thinks that is right.
Then higher secondary matter. দেখো। Hand over the slip. Yes.
One matter for inclusion in the list.
Under the heading motion, is a motion or hearing?
Hearing matter.
Hearing matter, wait. Now I'm not including any hearing matter. Already there are hearing matter. Yes. What correction you require?
Last Miladri name has been for it will be Nandini Shah.
Where is the order? Tomorrow to be mentioned for correction.
For direction, we should be listed in the monthly list of April.
So the file has to come. File has to come. We will hand over the slip. নিয়ে নাও দেখো ফাইলটা আনাতে পারো কিনা দিয়ে দেবে। When assigned?
In the month of July. Was added in the folders act.
It is?
In the folders act. Thereafter, what people released on immediately thereafter the repeat card and the Aadhaar card was deactivated by the authorities without giving any opportunity of hearing. Thereafter, it was challenged with the High Court and an order was passed, and thereafter it was deactivated. Suddenly, my lord, they have
Now it is what is the date of assignment?
Date of assignment, my lord, 18 July. My lord.
Who is appearing for the what relief you are seeking?
For the birth certificate has been cancelled without giving an opportunity of hearing. That is why I am come up for your lordship. And the next date of hearing is in the 14th September. I'm trying paying for an improvement in the list, but it's not happening.
19th August. দিয়ে নেবে assignment এর। Please. First, your junior will mention. When she will fail, you will mention. I don't have so much time.
Kindly consider.
Sorry. Yes. Sorry.
Otherwise, my lord, by September it will be submitted through teacher in charge. Teacher in charge is reluctant to and flat.
I have taken up this matter. Matter was not ready. No service was. Sorry.
I have been told, my lord, why?
Head examinership is not your headache. Head examinership is not your headache. It is the headache of the board.
The intention I have done some.
Very good. Yes. Yes. Yes.
Application for restoration petition.
Restoration. Hand over the slip.
My lord,
Yes.
may I be permitted to be mentioned, my lord, item number 1073. My lord, the petitioner is a qualified candidate date 2011 for the upper primary, my lord, post of assistant teacher. The petition
Hearing or motion?
motion stretch lordship.
Motion. Upper primary TET to 2011. What is the urgency?
My lord,
2011 upper primary. Do you know when it was held?
my lord,
It was held in 2012.
my
Is
lord,
it appearing in the list?
yes, lordship.
Yes, very well. No urgency. Sorry.
Permitted to mention one matter for upgradation, my lord. My lord, the petitioner is an assistant teacher, my lord. Former he was an teacher in charge, my lord. My lord, the problem is that now,
Is it appearing in the list, madam?
my lord, but
What is the urgency?
my lord, the problem is that, my lord, from February onwards, my lord, the drawing and disbursement officer, my lord, has stopped the salary of the petitioner, my lord.
From which date?
From
which date salary stop?
my lord, from February 2025.
25. And when you have filed the writ petition?
My lord, April, my lord.
Then what was the order passed in April?
My lord, thereeafter the matter was came up.
April matter must have come as per the presentation form. What was the order passed?
My lord, your lordship was pleased to add the West Bengal Secondary Education Board, my lord, as party, my lord. Thereafter, my lord, the order was complied, but thereafter the
Matter is appearing at serial number.
252, my lord.
Let it be there. It is under the heading supplementary list. No further upgradation. Yes.
Bring the upgradation. Lordship, I'm for the petitioner, and the petitioner is a very elderly man, around 70 years. His pension has been pending since 2015. And this is the second round of writ petition that we are filing, and the numbers are still.
When the writ petition was filed?
Lordship, this was filed in April 2024.
2024. What was the order passed?
Lordship, it's a new phase.
April 2024, no order was passed.
Fresh writ petition. Before that, there was another writ petition in which his pension was halved. As in, the entire pension wasn't given.
Very well. Let me see. Yes.
Lordship, may I be permitted to mention 4 similar matters, Lordship? The matter pertains to supernumerary post and work education. Lordship, the petitioner is qualified in the first SLS.
Work education, supernumerary posts. There are several matters, and matters are to be taken up by a bench. Now wait for some time. Yes. Sorry. Yes.
One matter for inclusion
Inclusion motion.
No, under hearings.
Hearing, I am not including any hearing matter at present. Wait for some time.
Your Lordship, if I may be permitted to mention a matter for inclusion. It is in the monthly list.
Inclusion for motion.
Yes, Your Lordship.
Motion of which year?
2023.
Hand over the slip.
And Lordship, 2 more matters for upgradation, Your Lordship. They have been pending since the petitioner is an assistant teacher in both cases, and they have stopped receiving their salary since 2022. And
From 2022, your salary, wait for some time. Yes, no upgradation. Yes.
then
I'm
Your
permitted to
Lordship,
mention
if
one
you could
urgent
please
matter, my lord, for
kindly release the matters.
No upgrade. If it is not upgraded, then it has to be released.
If
There
you
is a,
could-
where is the bench?
Sorry, Your Lordship.
Where is the bench having determination?
For Honorable Justice Rajeshri Bhattacharya.
No, it's not having the secondary determination. It's not a secondary determination having. Show me any other bench where matter can be placed. All matters cannot be upgraded, and if it is not upgraded, then advocates will pray for release. It's pity.
Your lordship, actually the salaries have been.
Sorry, yes.
My lord, this kindly for inclusion.
Who is your senior? Which chamber you are attending? Whose chamber you are attending?
Senior, lordship, they and associates. They and associates.
DN?
They and associates. under
DN
the
associate, yes.
My lord, may be given permitted to be to mention one urgent matter, my
Yes.
lord. The matter relates to first SLST 910 recruitment process. The petitioner's name appeared in the 952 list, where on the in the OMR mismatch list, which was published by CBI. And then and there, immediately the petitioner filed one petition in 2023 before passing the judgment of the division bench of this Honorable High Court. And then it was set aside, and the Supreme Court also upheld the same judgment. And now it was part heard in 2023 before Honorable Justice Vishwajit Basu. And then after setting aside the recruitment process, again it was heard by Honorable Justice Vishwajit Basu, and he directed the Lordship directed that to take direction from Supreme Court, whereas whether this matter can be heard by the High Court. So the Supreme Court had said that High Court can hear it and decide upon her own merits individually. So, my lord, now Honorable Justice Vishwajit Basu has released the matter to take your lordship's regular bench. So, kindly, my lord,
It will take
kindly
time.
hear
No,
it.
it's not possible.
My lord, the petitioner.
It can appear under the heading
kindly
motion
consider
or hearing.
motion. My lord,
It appear in the monthly
kindly,
combined-
my lord, consider that petitioner has lost her job. She's a mother. She's lost her job, and she only
Sorry.
the mismatch
At
of
present
marks
is
can
not
be explained,
possible.
my lord.
Wait.
The mismatch of marks can
If
be
it is not appearing, let it appear in the monthly list of September.
one
Sorry, please don't in this fashion don't mention. If it was heard in part before a particular bench, now it has been released. If it is at the motion, is it at the motion stage or
For
hearing?
inclusion, my lord, I am.
Motion stage or hearing
Yes,
stage?
my lord. Motion stage.
There was no direction for affidavit.
No, my lord.
There is no direction for it. The matter was heard.
No.
Find it out whether it is motion or hearing. Yes, call the list. Yes.
Because my lord, I would not bother your lordship. One time your lordship heard it. My lord, extreme urgence. May I come tomorrow? Today I am not, my lord, because your lordship to give me chance, my lord. May I come tomorrow, my lord? If your lordship permit me, then only I mention, my lord. Otherwise, my lord.
There 19th August.
19th.
Yes, call the no further mentioning. Sorry.
For upgradation.
Sorry, no further mentioning. Mentioning is over.
Item number 1.
Who is for the petitioner?
Next.
At the time of call, no one appears for the petitioner and no accommodation is paid. However, state respondents and West Bengal Center for Service Commission are represented by learned advocates. Writ petitions are dismissed for default. Parties to act on the server copy. Next.
The appearance. Item number.
My lords, order dated 14th of July.
এখানে দেখুন এটা আবার ডিসমিস রিপোর্ট ঠিক আছে নেক্সট
Yes, what is your instruction?
Yes, no, no, that supplementary affidavit has been filed. There was an order. The school authority, rather petitioner through school authority already deposited. Other day I submitted, probably it was there, but evidentiary documents page 4 and 5.
Supplementary affidavit filed by the petitioner?
Petitioner is to file. In first half, 44,406 on 6/26.
When petitioner retired?
31st of March 2025.
Now he is not getting pension.
Nothing. And probably by virtue of this, in terms of their objection.
But this was deposited long back.
Long back.
September 2022.
22 and thereafter also July.
July 2022.
That is. And all these documents submitted at the time of e-pension.
Now petitioner was working as assistant teacher. Why pension is not being paid?
Documents that I earlier disclosed, my lord, that's why my lord, he has deposited the word on. He has deposited the word on money, my lord, just enclose here. Let's say, the lord is passed on.
No, what is your instruction? Why it is not being paid?
My lord, kindly see the.
Have you taken any instruction or any report from the DI? Why it is not being paid?
My lord, I have already, earlier occasion, I have deposited the instruction, my lord.
You have filed the instruction?
My lord.
Yes, yes, it is there. Just give.
Elimination করা নিয়ে, হ্যাঁ?
না। এজন্যই তো
Petitioner retired on 31st March 2025. Why pension pay case was submitted online on 26 June 2025?
Because
After 2 months.
subject to correction, because of those queries, again it was submitted through online by annexing all these documents earlier. Since page number 6 of the supplementary affidavit, there was some objection in pension payment order, all these documents returned back. Thereafter, all compliance. Supplementary affidavit, page 6. Earlier also, but it is the latest one.
Now, when the school authority filed the e-pension case,
Before the authority concerned, it was sent.
no, I want to
Let-
know simple thing. You are appealing for the school authority.
All right.
When e-pension was submitted before the authority.
Authorities. On 26th of 23rd of June 2020,
There is saying,
saying
as the school authority has not taken appropriate action regarding observation raised by the Joint Director of Accounts Education Nodia dated 25th June 2025.
yes,
And e-pension file has been pending at the end of the head of the institution from 25th June 2025 to 11th July 2025. So, from the present status of the e-pension file, it appears that the objection raised by the Joint Director of Accounts Nodia has not been cured.
all right, man. I am taking
So
instruction
therefore, up to 11th July 2025, nothing.
I got your lordship. I got the report also from the 5 minutes. I'm taking time.
5 minutes.
5 minutes of your lordship's time.
No,
I'm
no, I have heard this matter twice.
My lord.
So again, 5 minutes is not possible.
Yes.
So therefore,
If it is not there, I have to make any.
yes, if you obtain an instruction and file a report that why up to 11th of July this pension file was pending before the school.
Well.
authority. Yes.
Man.
Supplementary affidavit filed on behalf of the petitioner is taken on record. Stop. It is submitted on behalf of the school of the petitioner as well as the school authority that alleged excess drawn amount was deposited on 26 July 2022 and 15 September 2022, copy of TR forms are enclosed to the supplementary affidavit. Taken on record বলেছি তো supplementary affidavit টা. Stop. According to the petitioner and school authority, since excess drawn amount was deposited, there should not be any impediment in releasing retirement dues including pension to the petitioner in view of petitioner's superannuation on 31st March 2025. Stop. Next paragraph. However, a communication dated 11 July 2020. However, from communication dated 11 July 2025 of the District Institute of Schools AC Nodia, it appears that up to 11 July 2025, e-pension file was pending before the head of the institution. Stop. On query being posed to the learned advocate representing
Headmaster.
the school authority, accommodation is prayed for. Stop. Next paragraph. Respondent number 7 is directed to file a report disclosing when making ready when pension case of the petitioner along with service book were made ready and same were forwarded to the district institute schools AC. Nodia being respondent number 4. Stop. Next paragraph. District Institute of Schools AC Nodia is also directed to file a separate report disclosing as to why till date pension of the petitioner has not been released. Next paragraph. Let both the reports be filed by fortnight from date. Stop. List the matter under the same heading on 1st September 2025.
Obliged. Up to date status report I shall get.
2nd September. 2nd September.
Yes.
Next. Oh.
Item number 3.
এই যে নামটা সোমনাথকে দেখে পাঠাও আসতে বলো আসতে বলো
But earlier occasion, your lordship directed me to ask a specific notice to the state advocate, my lord, I have asked.
who is appearing for the state
Mr. Taufik Ahmed Khan and Himanshu Ghosh. My lord, I have served Mr. Ghosh. This is আগে দিনও আসেনি।
দেখি দাও 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 একটু দেখো দেখুন লক্ষ্য করুন তো নিয়ে দাঁড়িয়ে আছে এরকম ভাবে Please, what is the matter about?
The matter relates to my lord family pension of a my lord widow daughter whose father my lord retired from service before promulgation of the Act of 1981. This is covered by the larger bench now. My lord, earlier occasion, this writ petition was moved and order was passed, page 43. The concerned district inspector.
This is the writ petition filed by the present petitioner.
Present petition. This honorable court directed the respondent to consider in terms of the three judges bench order.
With prescription.
Page 44 is the recent order. ওখানে সর্বনাশ। Page 44, last paragraph, your lordship will find the ground is taken that this is 381 case, that's why it cannot be considered. Page 44. Column number 6. Now page 45.
Last one.
Yes.
So this pension was not sanctioned in terms of 15th May 1985 memorandum.
Yes, because the next paragraph.
It was sanctioned in terms of the memo dated 1st October 2010.
Yes.
So the three judge bench judgment is with regard to ROPA 90 the death cum retirement benefit scheme 1981.
Yes.
How this can be extended?
Next page, next para. In this instant case, the petitioner's father, late Manoranjan Rai, retired on 30/11/79, which is before the date of effect of memorandum dated 136 CDNP 15/5/85, that is 1481. So there was no question to exercise option for pension, including family pension gratuity, in terms of the memorandum
Yes.
dated 1985.
Yes.
So that was considered in para 18 and 19. Kindly have it. Well, this is now settled, my lord. The state has preferred a SLP, but that SLP was also dismissed.
Paragraph 18 and
19. That was directed by this honorable court. Para 18 and 19.
Let it be decided on affidavit.
My lord, kindly not, my lord, your lordship kindly direct, I will again serve a notice, a short report. What I am asking, to set aside and consider in terms of the 2010, nothing else.
No, setting aside has to be based on, it's not mechanical setting aside.
No,
Setting aside has to be based on the merit.
merit.
So first
Well,
of
merit,
October,
my lord-
you show me that 1st of November 2010 circular
Yes.
confers right upon the unmarried daughter to get pension.
Next, last paragraph.
Issue.
Last paragraph, page 13. My lord, kindly note that.
In the writ
My lord,
petition,
affidavit will make,
in
my lord, the petitioner, my lord,
in the writ petition memo dated 28 December 2024
the
is
matter should be
questioned.
decided by the larger bench.
Is questioned whereby District Inspector of Schools AC Birbhum has refused to grant family pension to a divorced daughter, unmarried,
Widow daughter.
to a widow daughter of deceased teacher who retired on 30th November 1979. And received pension in terms of memo dated 1st November 2010, comma, not in terms of DCRB scheme 1981. Next paragraph. On perusal of this impugned decision of the District Inspector of Schools AC concerned dated 20th December 2024, this court finds legality of the same needs to be decided on exchange of affidavits. Next part, let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Stop. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next paragraph. Petitioner is granted leave to. Now, petitioner is directed to communicate this order to the non-appealing respondents or communicate this order to the respondents by 7 days from date and file further affidavit of service on the next date. উপরে করে দাও, in spite of service of notice, state respondents are not represented.
But in 2010, November 2010 also decided. This is decided by the larger bench.
Good.
Yes, Your Lordship, I am for the petitioner. What is the benefit of service?
Yes.
My lord, regarding my lord, withholding of the payment of the pension, my lord, pension to the petitioner who retired on 30th November 2024. Prior to that, my lord, 1 year before that, pension papers, all papers are submitted with the district schools.
30th November 2024.
30th November.
Retired.
Retired.
From
Prior-
which post?
From the post of headmaster of a higher secondary.
When your pension papers were submitted before
On
the school.
30th
You are appearing for Mr. Saurabh Sen?
State.
State. When papers were submitted before the DI?
30th January, my lord, January 2023.
30th January 2023.
My lord.
Pension papers were submitted. 30th January 2023.
22nd January 2023. 22nd January 2023. Before the
Retired on 30th November 2024.
yes. Prior to that, 1 year.
2 years before.
24 he retired. She retired.
Yes. 30th November 2024.
23 the pension.
February.
November.
What is the date when pension papers are submitted before the DI?
On 22nd January 2023.
That means 2 years before, nearly 2 years before.
1 year, my lord, not
No.
2 years.
Entire 2024 up to November. Entire 2023 from January 2023.
That happened, my lord.
So you are sure, you are correct in
Yes.
your submission that on 3rd January 2023,
Yes.
3rd January 2023,
That
this was
22nd
submitted before the DI.
22nd January 2023.
22nd January 2023, it was submitted before the DI. Yes, Mr. Sen, why this has not been
No.
calculated?
No, my lord.
Madam,
Thereafter,
what-
my lord, objections have been raised by the pension authorities, my lord. Subsequently, 3 objections were raised, my lord. 3 objections were ultimately.
What are
my lord,
those objections?
My lord, DI, my lord, acted upon that, and subsequently the last objection, that is, my lord, the last annexation in the writ petition appearing at page 50 to 52, my lord. The last objection was raised, my lord. My lord, today, my lord, the DI had handed over a copy of the communication that has been made to the Deputy Director of School Education, granting it to take necessary steps, my lord, regarding objection. My lord, will kindly go through.
The objection.
It has been submitted on 8th, my lord, 8th of August, my lord. Page 3, my lord, of that.
Now, what is the objection? Please clarify.
But so far
Paragraph 4 of your statement.
that excess withdrawal.
Let me understand what is the
That page,
objection.
my lord will kindly consider page.
Yes, please come to 4, paragraph 4.
Paragraph 4, my lord.
Please clarify it.
Fixation of to comply with the objection raised by the Director of Pension and Provident Fund Group Insurance, the Deputy Director of School Education, West Bengal, in terms of order number such and such, clarified the matter. The benefit of fixation of pay under the revised pay structure will be available to the petitioner, taking his earlier benefit of additional increments in the unreserved scale,
In unrevised scale.
unrevised scale, irrespective of the fact that he is in service on 27th of February 2009 or not.
It is not clear to me. What is the objection? That is the crux of the issue. Please clarify.
But so far as the objection,
Where is the objection? Let me see.
but page 39.
No, I have to decipher from here. Paragraph 4. Please clarify.
But page 39 is the objection raised by the Malad, the pension authority.
Yes, that is the basis.
Malad.
Based
That-
on which matter was sent back to the school.
But-
Now, what is this objection? I cannot follow.
But so far as paragraph 4 and the objection raised, Malad, it differs, Malad. Malad, only today, Malad, I have got this, Malad.
No, last occasion time was obtained by your
Malad, the
junior.
last occasion time
Sorry?
was obtained.
You tell me because the
Malad.
teacher retired far back. I will not grant further time. You have to clarify it.
Malad, my instruction is, Malad, that if the
Court will not invent objection.
Malad, if the matter is adjourned, Malad, the matter will be resolved, Malad, by 2 weeks, Malad. But today, Malad, I had a talk.
What
with
is the
PI.
crux of paragraph 4 is not clear to me.
Malad. But
What
it,
is this?
it differs from the objection raised by the pension authorities also, Malad. Malad will kindly see the pension authorities page that excess withdrawal has been made.
On the ground,
That is the
difference between my school education directorate and also the DPVC. I have annexed the document. They stated that there is no my failure wrong calculation of pay scale of petition.
Who has stated?
One is the director of the director of school education. I have annexed the
Where is that memo? Show me.
my lord, kindly see page 13. My lord, P13.
Page?
My lord, page my lord, page 46.
Merely sitting at the chair, raising one after another objection, and the pension cases are being stalled unnecessarily.
Malad,
Page?
My lord, page 13.
Page 13.
Yes. P13 and next 46.
Which page?
461 46.
It has been clarified well, page 46.
My lord, I have seen, my lord. My lord, as such, my lord, there is no impediment, my lord.
Based on this clarification, within 4 weeks, you will settle the pension and release the amount. It has been clarified well. Rather, the DI's clarification is not clear. No, not even you are in a position to answer the query of this court.
As such, my lord, so far as paragraph 4 is concerned, my lord, it's a little bit inconclusive.
The provision is not akin to 185 ACB in case of headmaster, where this incremental component merged with the basic pay. That's why it is stated that ROPA 2009 was introduced with effect from 1st of January 2006. The provision of GO number 185 ACB dated 4th May 2000 could not have any application to guide fixation of pay under ROPA 2009. In the said GO number 181 ACB dated 8 October 2009, there was no provision to seize the aforesaid additional increment when she was appointed as headmaster on 1st of January 2006. So therefore, the petitioner is beneficiary to this GO number 181 ACB dated 8 October 2009.
Right.
So this was not altered in view of introduction of ROPA 2009. Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner was an assistant teacher. Petitioner initially was an assistant teacher who was appointed as assistant headmaster on 1st September 2005 in the school where petitioner was working and joined the post of headmistress in Kharagpur South Side Girls High School on 21st August 2007 and retired on superannuation on 30th November 2024. Stop. Grievance of the petitioner is till date. Her pension and retirement and other retail dues are not released on settling pension case. Stop. Next paragraph. It is submitted by the learned advocate representing the state respondents. Or it is submitted by the learned senior advocate representing the state respondents. That objection was raised by the Director of Pension, Provident Fund and Group Insurance. And to comply the same, Deputy Director of School Education issued a memo dated 29 January 2025. Deputy Director of School Education within bracket GA করবে। Wherein it was stated that benefit of fixation of pay under the revised pay structure would be available to a teacher taking his earlier benefit of additional increments in the unrevised scale, irrespective of the fact that state teacher is in service on 27th February 2009 or not. Next paragraph. However, on perusal of records, it appears issue has been rightly adverted to by the Deputy Director of School Education within bracket GA. Vide said memo dated 29 January 2025. Thereby clarifying that additional increment which was allowed to the petitioner as assistant headmistress on 1st September 2005 while she was appointed as headmistress on 21st August 2007. In terms of second paragraph, of Government Order number 181 hyphen capital S capital E within bracket capital B close bracket dated 8 October 2009. Stop. After implementation of ROPA 2009 with effect from 1st January 2006, the provision of GO number 185 hyphen SE within bracket B close bracket dated 4th May 2000 would not have any application to guide the fixation of pay under ROPA 2009. But said GO number 181 SE within bracket B dated 8 October 2009. Was not seized or did not seize karo, did not seize. কি বললাম সেন্টেন্সটা বলা হচ্ছে বাট থেকে, বাট বাকিটা কেটে দাও। 8 October 2009 did not contain any provision to seize the additional increment which was granted to the petitioner when she was appointed as headmistress on 1st January 2006. Now, when he was appointed as headmistress, after 1st January 2006. That was on 21st August 2007. Stop. Next paragraph. In view of the clarification offered by the Deputy Director of School Education within bracket GA West Bengal, this court finds by this time, in view of aforesaid clarification offered by the Deputy Director of School Education within bracket GA close bracket West Bengal, with a memo dated 29 January 2025. By this time, state authorities ought to have released retirement dues, including pension, in favor of the petitioner. Considering date of retirement of the petitioner on 30th November 2024. This court finds there is no justification in keeping the pension case of the petitioner pending. Next paragraph. Where the pension papers are lying now.
DI of schools.
Where pension papers are lying? Tell me.
Where?
Yes. You should aware of.
Well, it appears page 51. Only kindly.
I want to know from you where petty pension papers are lying. Whether it is lying in school or in DI office or in Deputy Director of Pension Provident Fund and Group Insurance, where it is lying.
My lord, DI of schools. As we call DI.
DI of school, last page of the instruction, it has been forwarded to the Deputy Director of School Education grantee name. That's the memo.
So the Deputy Director has already has given clarification on 29 January 2024.
Subsequent last objection, after the last objection was raised,
Next paragraph. Next paragraph, the state authorities are directed to immediately forward the pension file of the petitioner or pension case of the petitioner to the Director of Pension Provident Fund and Group Insurance, being respondent 4 by fortnight from the date of communication of this order. Stop. On receipt of pension papers, respondent number 4 is directed to issue pension payment order in favor of the petitioner by fortnight thereafter on compliance of necessary formalities. State respondents are directed to release retirement dues including pension to the petitioner at an early date, but not later than 8 weeks from the date of communication of this order. Next paragraph, with petitioner has disposed of urgent xerox at the copy. Next.
Item number 5. Item number 5, I appear for the petition, my lord.
I am for the state, and for the commission.
But on the last occasion, my lord, your lordship was pleased to direct me to serve a notice on the schools, my lord. They are still unrepresented, my lord. I have already served the notice via post, but
Whether service is complete or not.
no, my lord, it is not. I have mailed them a copy of mail.
But you have filed it on 25th June 2025.
Lord, I have the affidavit of service with me. That is done. But another notice, your lordship directed me to serve another notice to the school. That is in process, in the process of delivery. I have served it via email.
Issue. At the time of call, learned advocate representing the petitioner has prayed for accommodation to complete service of notice upon all the respondents. Stop. You have not filed affidavit of service.
My lord,
Last occasion. Whether it is by this affidavit service was complete.
Yes, my lord.
Upon all the respondents,
All the
including
respondents.
school.
Yes, my lord.
Show me the service upon the school.
My lord. There is the school management committee.
So last occasion, why this matter was not, why court directed?
Lord, the school remains unrepresented still.
So no objection has not been given by the school authority?
Yes, madam.
No objection has not been
Page
accorded.
47, madam. This is an offline application on distance ground, madam. In prescribed format made before the school authority. Page 47 is the
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner prayed for why you are coming after such a long time? This decision was taken by the school authority on 31st August 2021.
My lord,
And this
then
writ petition was filed on 25th June after 4 years.
my lord, subsequently, I got married and then I had a child. The child is of 1.5 years right now. My lord, in 2025, in the month of April, I made a subsequent application. I sent it to the DI. I sent it.
Not this application. Not this application which was preferred on 29th August 2021.
Subsequent to that, my lord, in 2025, I again preferred an application.
Yes.
My lord, that in that application, the school has not given any no objection, nor has forwarded.
Where is that application?
My lord, I'll show it to you.
page 43, madam.
Lord,
That is the latest application.
Latest.
Earlier.
3rd of April 2025.
Yes. That the previous application probably has lost its force by filing a subsequent application. Every service for petitioner has made an application for transfer in prescribed pro forma on 30th April 2025, but the authority of Chhatrasal Radhanagar Bireshwar High School, Hooghly, being respondent number 4, 5, and 6, have not issued no objection, quote unquote, in favor of the petitioner, triggering the present writ petition. Stop. In spite of service of notice authorities of so and so school or authorities of so and so school being respondent number 4, 5 and 6 are not represented today. Stop. Next paragraph. Learned advocate for the petitioner is directed to serve another notice enclosing copy of this order by 7 days from date upon respondent numbers 4, 5 and 6 and file further affidavit of service on the next date. Next paragraph. List the matter under the same heading on 26th August 2025. Next.
Item number 6.
Not for the state respondent.
Yes.
Of the petitioner retired on 30th June 2025. Before the retirement, an objection, my lord, has been given, that is on page 35, that 3% additional increment which has been, my lord, given to the petitioner by way of approval by the DI, that has to be given back from the date of upgradation. My lord, the circular which has been, my lord, referred here, which is subject matter to the, my lord, writ petition of this honorable High Court as well as division bench, and your lordship has decided. My lord, I retired on 30th June and a calculation has been made by the school authority, an amount of rupees 3,94,000.
Where is that calculation?
My lord, calculation is page 36. And objection is on page 35. By the Joint Director of Accounts, my lord.
Three lakh 94,896 was shown as overdrawn.
Overdrawn.
On account of additional 3% additional increment.
And the objection is on page 30.
You are the headmaster of a higher secondary school.
High secondary school.
Issue has been decided.
My issue was decided, my lord.
Yes.
But allow me a 7 days time to come back with the instruction.
What instruction is required after issue is decided?
Yes, my lord. Issue is decided. Even my lord sitting with sitting in a division bench has also.
Last occasion you prayed for time.
No, yes,
on 7th August.
Yes, on the over virtual mode. Yes,
yes.
My lord. Yes,
issue has already 3% additional increment is considered right up to the division bench, and it has been decided in favor of the teachers that it is admissible to the teachers. They are entitled to get this benefit.
Yes, my
if the headmaster was working at the time of upgradation of the school from secondary school to higher secondary school. After that, why your DI is raising this objection and has calculated this overdrawn amount?
My lord, that is the point I was trying to seek the instruction. And in another matter, my lord, involving perhaps the same issue, my lord, please to direct the commissioner of the
that is not the issue related to 3%.
To make a representation.
That is regarding directing the authorities to decide the claim.
Here, my lord, approval.
Here, petitioner has retired.
Here the case is yes, to that
now,
extent.
if I direct the commissioner, then his pension will be stalled.
But only on that objection
and he has enjoyed this benefit. Why he will submit refund this amount when the issue has been decided? On those matters where this benefit was not granted to them.
The distinction is there, my lord. I appreciate.
By 22nd March 2017 circular, which has been indicated in Joint Director of Account, that has been set aside by this honorable court. Single bench as well as.
But if your lordship feels so, my lord, allow me to comment. Since there was an objection, my lord, on that score, my lord.
Let him take an instruction and
Yes,
come back in order to apprise this court that why this overdrawn was calculated.
Yes, my lord.
If it is on the ground of 3%, that will not survive.
That is covered by the order. A fortnight time will be enough, I think, my lord. The objection to come.
Just a minute, page 35.
Yes, page 35, my lord, kindly have a pay of headmaster of higher secondary school is to be fixed as per memo number dated 22nd March 2017. So PSA is requested to recast with effect from 1/7/2012 till the date of retirement. This 22nd March 2017 is the subject matter challenge of the my lord of that 3% additional increment, my lord, penultimate paragraph, my lord, of Justice
Subir Kumar Ghosh's matter.
Yes, as well as the division.
Kali Sadhan Bhattacharya.
Yes,
that has been set aside by this honorable court.
So let him obtain
Yes.
instruction and come back.
Yes.
Yes.
Will automatically indicate that, my lord.
Yes.
Definitely indicate.
Affidavit, file your affidavit service.
My lord, earlier occasion.
You have filed it?
Yes, yes.
Yes. Petitioner retired on superannuation on 30th June 2025.
Sorry, I mean fortnight.
And the client advocate representing the petitioner has submitted the till date retirement dues have not been cleared. In his favor, or it has not been cleared. Stop. It is also submitted that it was assessed by the District Inspector of Schools. It is by DI.
No, my lord, the school authority.
School authority.
Yes, my lord.
Now this that page 35 is by DI, issued by the DI.
This is by the joint director of accounts. And
Have you made joint director of accounts
yes,
as party?
yes, yes.
Where from you are getting that authority, joint director of accounts?
My lord.
Joint secretary.
Observation raised by DPPG,
My lord.
not joint director.
DPPG, my lord.
Observation raised by director of DPPG. That means that your pension file was returned from DPPG to DI.
DPPG to DI.
Where the pension file is now
is pending before the DI.
DI. So it was observation was made by DPPG, approved by DPPG, observation raised by
yes,
DPPG.
DPPG.
হ্যাঁ কি বলছিলাম?
DPPG কে করেছেন তো পার্টি করেছেন তো?
না, it was assessed by the Director of Pension, Provident Fund and না কি বল সেন্টেন্সটা বলতো চেঞ্জ করে দিই। That an objection was raised by Director of Pension, Provident Fund and Group Insurance, being respondent number four. That pay of the petitioner being headmaster of higher secondary school is required to be fixed as per memo number 292-SL/SS-294/12 dated 22nd March 2017. Stop. Based on this objection, school authority has calculated
this amount.
Now in Subir Ghosh, where it has been set aside, Mr. Mitro?
Yes. Last page, my lord, page 11.
22nd March 2017,
yes.
Right? Let me dispose it of. Nothing remains. Give me the judgment of Kalishadan Bhattacharya in my usual order. Yes.
Usual order to the usual order.
Very well. This is the judgment of Kalishadan Bhattacharya that will suffice. Yes. কি বলছিলাম? Stop. Based on such objection, school authority has downgraded the pay of the petitioner, thereby assessed rupees 394,896 as overdrawn amount, which overdrawn amount. Stop. According to the respondents, such excess amount is required to be refunded by the petitioner for finalizing pension case. Next paragraph. State respondents are represented by learned advocate who has made submission to defend the objection raised by the Director of Pension, Provident Fund and Group, or raised by respondent number 4. Next paragraph. আচ্ছা এর আগে আরেকটা লাইন অ্যাড করে দাও ওই স্টেটের যেখানে পিটিশনারের সাবমিশনটা রেকর্ড করছিলাম। In support of the case made out on behalf of the petitioner, reliance is placed on the judgment of a coordinate bench dated 15 January 2024, passed in WPA 6217 of 2021, within bracket Shubir Kumar Ghosh versus the state of West Bengal and others, and the judgment of the Honorable Division Bench dated 3rd December 2024, passed on an intra-court appeal being MAT 1002 of 2022, within bracket state of West Bengal and others, versus Kali Sadan Bhattacharya alias Bhattacharya and others, close bracket. তারপরে ওর সাবমিশন তারপরে on consideration of the submissions made on behalf of the parties, it appears the basis of calculating excess drawn amount requiring petitioner to refund the same is memo dated 22nd March 2017. Stop. It is rightly pointed out by the learned advocate representing the petitioner that he or she was headmaster of a higher secondary school, and due to upgradation of the school, petitioner enjoyed 3% additional increment. 3% additional increment. Stop.
Which has been
Such right of the petitioner to get the benefit of 3% additional increment, being headmaster of a higher secondary school, is fortified by the judgment delivered in Shubir Kumar Ghosh Supra, as well as the judgment fortified by the judgment delivered in Shubir Kumar Ghosh Supra by a coordinate bench, and the judgment delivered by the Honorable Division Bench in Kali Sadan Bhattacharya Supra. Stop. It appears that issue is no more res integra. Stop. Next paragraph. Therefore, the objection raised by the petition, objection raised by the respondent number 4, that petitioner is required to, objection raised by respondent number 4 for downgrading the payment or downgrading the pay of the petitioner by withdrawing 3% additional increment is not found to be sustainable. Consequently, pay fixation made by the school authority is also set aside. Next paragraph. Now it is pending before the DI. Stop. The next paragraph. District Inspector of Schools AC, Paschim Medinipur, being respondent number 5, is directed to forward the pension case of the petitioner along with relevant documents to the respondent number 4 by fortnight from the date of communication of this order. Stop. On receipt of pension case, respondent number 4 shall issue pension payment order by fortnight thereafter on compliance of necessary formalities. Next paragraph. State respondents are directed to release retirement dues, including pension, in favor of the petitioner at an early date but not later than 8 weeks from the date of communication of this order. Writ petition stands disposed of. Urgent xerox certificate copy.
Great. In terms of last pay drop, well, no.
Yes, I have set aside the pay fixation.
Been mentioning in the morning.
Item number 7.
Yes,
This is the voter card where it appears. Yes, there is a residential address.
there is
a residential address, but petitioner only procured this document, but petitioner is not.
you have a residence at Gorbeta?
Gordbeta. But my lord, kindly go through the once a rule. My lord, distance stated. My lord, distance.
So why you have not disclosed it in your writ petition?
My lord, I am staying in my lord, in my lord.
In the writ petition, it is stated Anandapur. Why?
Anandapur. My lord, both the my lord in service book, my lord, original service book I have. In even the recommendation, both the appears I am residing in Anandapur. Even I am residing originally in Anandapur.
Why you have not disclosed it that you have a residence at Gorbeta?
Subject to correction, my lord, it has purchased due to for the accommodation of my child. My lord, my entire family is staying there. My lord, kindly see the
Where staying?
My lord, in Anandapur. In Anandapur, my lord, service original.
Why you have not disclosed it in the writ petition?
My lord, it has been purchased, but my lord, a person subject to correction, a person may have 2 or 3 residents. My lord, service book, it's a school document. My lord, I am staying in, my lord, Anandapur. In recommendation, Anandapur, even rule stated, my lord, which residence, my lord, it has been mentioned in the service book, that should be considered.
How much cost is to be imposed?
My lord.
Lordship, this is
That petitioner is also
residence certificate গর্ভদাতে আছে মানে যেটা বলে
Annexure কি আছে? Annexure তো ওই তো ভোটার না
এদিন অন্যটা
ভোটার
পুলিশ
ইনফরমেশন স্লিপ আছে What is the distance in between Gorbeta and your school?
Gorbeta and school is 18 kilometers. And Anandapur is about.
I'm not concerned with Anandapur.
But it is medical, subject to correction, it is also medical ground transfer. It is not on distance ground transfer.
Issue.
Lordship, I am appearing for the state. This is the instruction got by Gorbeta PS, Lordship.
Yes.
Gorbeta. দিয়েছি দেওয়া আছে
Gorbeta Gram Panchayat issued a certificate
Yes, Your Lordship.
that the petitioner, wife of so-and-so,
She is resident of there, Your
is
Lordship.
permanent resident of Gorbeta Gram Panchayat under Gorbeta 1 block.
And voter information is also in
For
the.
how many places you are in respect of, in connection with your, how many residences you are voter?
Voter one. But at the time that I'm not.
I'll direct the board to initiate proceedings against you for your conduct. You have tried to outwit this court. Police authority is saying that he is the permanent residence, and this is the residential certificate issued by Gorbeta Gram Panchayat.
Next is the voter information, Your Lordship. Next annexure.
And this is voter information in
Uma Devi Girls School polling booth of Sonali Day.
We have prepared this drafting basis of the as per rule. Rule says
is a teacher. What lesson she will impart to the students? Mr. Ghosh Chaudhary, if this is the conduct of the teacher, then what lessons she will impart?
Gorbeta is the parents' house and Anandapur is the in-laws' house. She is my neighbor, Lordship. That's why I know.
So she stays with
And
the
in parents' house because of to attend the school. It is nearer, only 18 kilometers from Gorbeta to that school, Uttarbil school. Anandapur is her in-laws' house.
there is it has been stated everywhere. Subject to
Issue.
constitution,
In terms of the order date 7th August 2025. Petitioner has কি বললাম এটা matter is taken up for consideration today. When learned advocate representing the petitioner submits that petitioner has residence at Gorbeta and distance in between her residence and the present school is 18 kilometers. Stop. Next paragraph. Officer in charge, Gorbeta Police Station, Paschim Medinipur, has made a communication dated 10th August 2025 to the learned advocate representing the state respondents, wherein on inquiry it was informed that the petitioner is permanently residing at village Lapuria, EOPS Gorbeta, district Paschim Medinipur. Stop. In support of same, one certificate dated 7th August 2025 issued by Pradhan Gorbeta Gram Panchayat, Gorbeta 1 block is also enclosed, wherefrom it appears that petitioner is resident of Gorbeta. Stop. One voter information slip is also enclosed to the communication of the officer in charge, Gorbeta Police Station, dated 10th August 2025, wherefrom it appears petitioner is voter of 233 Gorbeta Assembly constituency and corresponding polling booth is Gorbeta Uma Devi Girls High School. And part serial number of the petitioner being voted is 41. Stop. Next paragraph. The communication dated 10th August 2025 along with certificate issued by Gorbeta Gram Panchayat and voter information slip are taken on record. Next paragraph. It is surprising that writ petition is filed praying for transfer on the ground of distance by projecting it is on medical ground.
Yes, medical ground,
It is stated that
child medical ground, cardiac ground.
So why you have given the wrong residence in that event?
he has stated 58 kilometers.
Yes,
In the
yes,
petition.
stated 50 distance is 58
But it
kilometers.
is 18 kilometers.
50 from my lord,
Anandapur.
Yes.
But she is not
Why
staying
Anandapur
there.
is being projected?
my lord, as per service.
Which paragraph?
Lordship. প্যারাটা দেখা তো।
And my lord,
Paragraph 6, your lordship.
as per rule also, it has been stated clear, which is
কি বলছিলেন?
Paragraph 6, second line.
না, praying for transfer বাকিটা কেটে দাও. Praying for transfer, and in paragraph 6 it has been paragraph 6 of the writ petition it has been averred that the distance in between the residence of the petitioner and her school is 58 kilometer. Stop. In the writ petition it is projected that petitioner is staying at Anandapur, Paschim Medinipur, not at Gorbeta. Stop. It appears that petitioner has not come before this court with clean hands. Hence, writ petition stands dismissed. With a note of caution, if such conduct recurs in future, same shall be dealt with appropriately. Next.
Item number 8.
The petitioner, my lord, in terms of the Supreme Court order, my lord, the petitioner was terminated from the service. My lord, petitioner participated in the both selection process, my lord, the upper primary and my lord, the SLSC.
Petitioner lost service.
Yes. My lord, the petitioner, my lord, up to call for interview. My lord, at the date of interview, petitioner was admitted in the hospital. That is the apartment, the medical documents is there. For that reason, her husband appeared before the interview board, praying for another date, but that has been denied. This is the representation I have stated in page 110.
Dismiss leak pen.
আমার 24-এর এন্ট্রি মডেল আজকে এক্সপায়ার করে যাবে, তার আগে 23 আছে।
Now you did. Thing is this: you did not participate in the interview.
Yes, my lord.
So how this relief can be granted to you?
Subject to lordship correction. Well, in that date, petitioner have no.
And
knowledge.
this was personality test was fixed on 21st October 2022.
Yes, absolutely. my
You have filed this writ petition in 2025.
After my lord, pass the order.
2025.
My lord, because
The story is coming up in 2025, not then.
my lord, what happened as per their notification?
My order.
But as per their notification, nobody will be permitted to participate in the interview process as per their circular. But
I have decided the issue.
but this is my matter. Your
There is
lordship
nothing
decided.
different in it.
But
Had you approached the court within time after being disallowed,
no scope.
then I could. After losing the job, you are coming for praying for a direction to hold interview at this stage.
Because
That I will not
in-service teacher joined after the my service was terminated. Because they had
My lord
not
will
been
kindly excuse
permitted,
me.
my lord.
Yes, yes.
I have also, my lord, covered by the C. Lalita judgment. But
Class
similarly,
9 and 10, petitioner was working.
my lord, the 9, 10. The latest one, my lord, which order, my lord? Lalita judgment. Next.
Issue.
Item number 9.
I'm for the state respondent.
Yes, service
Transfer on my lord medical ground. My lord, pending before the commission, self medical ground, but previously applied on my lord distance ground. It has been rejected on the ground of subject teacher, then special, and my lord medical. Page 33.
Page 33.
But my lord, there are other vacant.
It is on medical, last application is on medical ground.
Ground.
When distance ground application was rejected, then medical ground application.
Distance ground rejected, then the medical ground, rather there are say, vacancies are available, my lord, which has been notified.
What medical ground?
Self medical.
What is the element?
Gynecological disorder.
What is the date of application?
My lord, date of application 17th, last application 17th of May 2022. It has been reached to the commission 29th of June 2022. And first application.
We're coming after 3 years.
Yes, what is that?
Yes.
Yes.
Why you are coming after 3 years?
But my lord, it is true. But
yes.
My lord, previous application when made distance ground application, admittedly school issued the NOC. We should never objected since the capability is there, school can manage it. Right? It has been rejected from the SSC. First application, which is with distance ground application. School issued the NOC, and since school has no problem. My lord, kindly see. 20.
Let a fresh medical examination be done. Pilot every service filed on behalf of the petitioner is taken on record. Petitioner made an application for transfer on Uchotsu portal on 17th May 2022. Since petitioner was suffering from gynecological disorder. From the document at page 33, it appears that petitioner was medically examined in June 2022, and it is submitted on behalf of the learned advocate it is submitted on behalf of the respondent authorities that 3 years have passed in the meantime. Stop. Therefore, due to constant treatment and care, health condition of the petitioners may have improved. Next one. Having considered the respective submissions made on behalf of the parties, District Institute Schools AC. Number 5. Paschim Medinipur, being respondent number 5, is directed to obtain medical report from the concerned Chief Medical Officer of Health / Medical Board by 4 weeks from the date of communication of this order. From the concerned Chief Medical Officer of Health and Medical Board on medical examination of the petitioner by 4 weeks from the date of communication of this order. In the medical report, concerned CMH / Medical Board is required to opine considering present health condition of the petitioner, whether petitioner is required to avoid long distance journey or not. If petitioner if medical report justifies transfer of the petitioner, stop the justifies transfer of the petitioner, same along with transfer application shall be forwarded to the chairman West Bengal Central School Service Commission, being respondent number 4, by fortnight thereafter. Stop. On receipt of transfer application, respondent number 4 shall decide the same in accordance with law within a period of 8 weeks from the date of communication of this order. The decision to be taken by the respondent number 4 shall be communicated to the petitioner by fortnight thereafter. Next paragraph, it is made clear suspension of portal shall not be a ground to reject transfer application of the petitioner. Writ petition stands disposed of, urgent xerox circular. Next.
Item number 10.
I am for the commission.
But distance ground transfer application in respect to forma offline. The transfer application on 2nd June 2025.
Some time to the authority.
Yes, for a take.
But we filed an application, preferred an application on 2nd June, and writ petition was filed on 30th June. So where is the scope?
Well, at 12th June 2025, school authority issued the.
Yes.
That they are unable.
Why within a month you are filing this writ petition?
That is the last matter which I have filed. Well, this is the time gap, short span of time. This is the last matter. Well, I have earlier occasion here. Well, school issued the NOC. Well, only.
So since this is the last matter, this illegality has to be perpetrated.
No.
Then?
Well, school, technically why I am filed this application. But that is the reason behind it, my lord. Since the portal is suspended, but school authority.
You will go to the DI, DI will take a decision.
Yes.
It's a medical ground application.
No, distance.
Distance gain. Then DI will forward it to the commission.
Yes, but school is unable to forward it, sir, because suspension of portal. That is why, my lord, when school issued the NOC and it is pending before the school. Only required to process the application through proper step. If otherwise eligible, my lord, let the DI can scrutinize my application.
But a school has issued no objection.
School had issued.
Who is appearing for the school authority?
School I have served. My lord, I don't find the endorsement here.
Basically.
Yes, who is for the DI? Issue. In spite of service of notice. File your affidavit service. State respondents are not represented. Stop. Learned advocate for the petitioner is directed to serve notice of the learned advocate representing the state respondent. Stop. It is next part. It is submitted that though school authority, though authority of Shondanga High School, HS, Nodia, being respondent 6 has issued no objection on 12th June 2025 on transfer application of the petitioner, but claim has not been forwarded to the West Bengal and has not been forwarded to the District Inspector of Schools AC Nodia, being respondent number 5 for taking further steps. The school authority is not represented today. State school authority is not represented today. Stop. Lied advocate for the petitioner is directed to serve another notice enclosing copy of this order upon the headmistress or upon head of the institution of Shondanga High School within bracket HS, Nodia. Being respondent number 6 by fortnight from date. Stop. On the next date, petitioner shall file further affidavit of service. Stop. Next paragraph. List the matter under the same heading on. 9th September 2025. Every service to board. Yes. Notice বলেছি। দুটোই ওদের join করছে। তুমি যা বলেছে করে দাও তাতে yes.
Item number 11.
My lord, I am for the state, my lord.
1 September.
Yes, yes.
Same.
Where is the application?
Page 25, online recruitment. 6 April 2022.
Page 25.
Yeah. The pilot content was any medical document.
Spouse medical ground.
Yes. Only one traveler has been issued the question.
Gynecological disorder. Let it be re-examined again. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner has made an application for transfer since wife of the petitioner is suffering from gynecological disorder. Such transfer application was made far back on 6th April 2022, and in the meantime, 3 years have passed. Next paragraph. Learned advocate representing respondent authorities have submitted health condition of the wife of the petitioner may have improved due to constant treatment and care, requiring fresh medical examination. Stop. Learned advocate representing the petitioner submits that if it is found necessary, fresh medical examination may be conducted to ascertain the present health condition of the wife of the petitioner. Next paragraph. District Inspector of Schools, AC, Murshid.
Respondent number 5.
Murshidabad, being respondent number 5, is directed to obtain medical report from concerned Chief Medical Officer of Health / Medical Board, medical examination of wife of the petitioner by 4 weeks from the date of publication of this order. Stop. In the medical report, concerned CMOH / Medical Board is required to opine, considering present health condition of wife of the petitioner, whether she requires constant care and supervision of her. So, if medical report justifies transfer of the petitioner, transfer application along with medical report shall be forwarded to the Chairman, West Bengal Central School Service Commission, being respondent number 4, by fortnight thereafter. Stop. On receipt of transfer application, respondent number 4 shall decide the same in accordance with law by 8 weeks thereafter. Stop. The decision to be taken by the respondent number 4 shall be communicated to the petitioner by fortnight thereafter. Next paragraph. It is made clear if it is made clear that that suspension of suspension of portal shall not be a ground to reject transfer application of the petition. So, this petition stands disposed of urgently.
Item number 12.
The state respondent.
Try for the school authority.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. However, state respondents and school authorities are represented by learned advocates. The restrictions called parties to act on the server.
Get finished.
Item number 13.
Item number 13, I am for the petitioner. My lord, the petitioner wants to, my lord, withdraw and my lord file fresh, my lord.
Why?
My lord, the petitioner participated in my lord, 2016 process and my lord has passed that the age relaxation process.
Is
Age relaxation in 2025 selection process. They were the participant of 2016 selection.
what you have prayed for in the
My lord, age relaxation. Already my lord has decided and division bench already decided. Division bench, my lord, division bench said since
who is for the commission?
in this process, in this petition, my lord, no challenge is made. No virus was challenged, my lord.
It has already been decided.
My lord,
You have filed this writ petition.
before, my lord.
Right up to yes, so nothing remains.
It is filed, my lord, kindly see, my lord, division bench order, my lord.
You have challenged this notification dated 29th May
My lord,
2025.
virus was not challenged, my lord, in this petition. That's why, my lord, I'm wanting to withdraw this
Virus
matter.
was challenged in those petitions.
No, my lord.
Those was these were considered, nothing remains.
My lord, that prayer was not
Where is the order?
considered, my lord.
Where is the order? Passed by this court and by the Honorable Division Bench,
My lord,
right
division
up to
bench and
Supreme
my
Court.
lord. My lord, kindly see my lord's order and the division bench. The prayer was not placed before your lordship. Not placed was there, my
Sorry,
lord.
I cannot grant you further leave since the issue is decided.
My lord's order, my lord. Kindly see, my lord, the page number 24 of the division bench order, my lord. It is specifically mentioned, my lord.
Once whole hog matter has been decided by this court, sorry. You should not have made this prayer.
But in those petition, my lord, that prayer was not replaced.
You are challenging this recruitment rules of 30th May 2025.
My lord, we in this petition, my lord, modification prayer is there, my lord.
Petitioners have questioned recruitment rules dated 30th May 2025 issued under memo number 1092/7016/CSSC/ESTT/2025. Issued by the Secretary, West Bengal Central School Service Commission. Legality and validity of the said memo dated 30th May 2025 was decided by this court on a batch of writ petitions. First one being WPA 12505 of 2025 within bracket Sanjoy Kumar Doloi and another versus the state of West Bengal and others. The judgment dated 7 July 2025. Stop. The judgment delivered by this court on 7 July 2025 was not interfered with by the Honorable Division Bench. With a judgment dated 6 July 2025, passed on an intra-court appeal being MAT 1017 of 2025 within bracket Orunima Pal and others versus State of West Bengal and others. So, issue travelled up to Supreme Court and SLP was dismissed. Stop. Next paragraph. Since issue is no more rescinding, stop. The writ petition stands dismissed. Urgent
In that matter, there is specific observation of that.
Next matter, sorry.
Because I want to challenge the two.
No further challenge, sorry.
No,
You can challenge it, but I have decided it. I have decided it, sorry.
See that one line, just one line. It will be kind enough.
Next matter.
Item number 14.
Transfer matter. This is offline transfer matter. On medical ground, my lord, the petitioner's husband, my lord, states 700 kilometers. They married in the year 2023. My lord, kindly turn 3 pages of my.
Where is the Supreme Court order in this matter?
My lord, Supreme Court order is there.
Yes.
Supreme Court order.
In Ashok Kumar Doloi's case?
Yes.
No, no, Arunama Pal matter.
No, no, first matter, this matter.
Arunama, my lord, this is not of matter. My lord, kindly we will not. Yes,
Sanjay Kumar.
Yes, Sanjay Kumar Dolo is not. This matter is not about Sanjay Kumar Dolo. My lord. They have basic difference. That's why, my lord.
We have challenged this memo dated 30th.
No, 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 age relaxation was not there. In this matter, my lord, I want age relaxation.
Yes, next matter.
I ask
Where is the Supreme Court order?
Well, just my yes. Soft copy, my lord.
Survey copy, give a copy.
Yes, yes, I have my junior.
Yes.
This matter, my lord. Offline application, my lord.
Have you made in application?
Yes, yes.
prescribed
In a
form?
prescribed
Where is
form.
that application?
My lord, page number 63. And she need it very badly, my lord. Because of that, why I will explain, my lord. Kindly, I don't want to, my lord, read page number 28 in open court, my lord. It will be kindly, my lord, peruse that page number 28.
Your application is at
Page
page
63.
63.
Yes, yes, my lord. And kindly peruse page number 20.
School authority has given no.
No, no, not yet. Yes, yes.
But at page 66, there is no.
Page 82.
There is
Page 82. Yes, yes. As my, yes, my lord. Yes, my lord. Page 82. It is given. It is given. Understand correct.
but no date, nothing.
My lord, that's.
No, no, it's 27th April. So what is
this?
page 63? Another application.
Earlier application.
No, my lord. This is the annexure of page 63, my lord. Because my lord will remember in rules, my lord, there is a specified format, my lord. Page 63 is the specified format, my lord. And is 79 also. Earlier, that is earlier.
No, no, page 63, there was an application.
Earlier application. Thereafter, taking NOC, my lord, page number 79. I stand corrected. And page, kindly peruse page number 28, 31, my lord. That's my medical report, my lord. And it's needed very badly. Why, my lord? I explain it. Page number 91 is the representation with no objection. Because she is aged about 44 years. And she have no child yet.
Now, where your application is lying?
To DI. Because school authority, after school authority,
Is it application on what ground? Transfer?
medical ground. Gynecological disorder, my lord, and all medical document is annexed with my report.
Now, have you whether the petition has been medically examined by the CM?
Because until and unless DI not considered, after DI consideration.
Why DI is not considering?
That is.
Who is appearing for DI?
The state is affidavit of service is there, my lord. State তাহলে একটু দেখে নাও না যেটা from the GP office.
When it was served upon the find it out.
It's served on 14 July. 14 July, just 1 month.
No, I have to give direction upon the DI.
Until and unless.
I am fixing a date. I will direct you to serve a notice upon the learned advocate representing the state.
Yeah, yes, madam.
Come.
Yes, yes. And madam, keep it just about because.
Yes, yes.
Because 42 years of age, madam.
Matter is heard in presence of the learned advocates representing the petitioner, comma, West Bengal Central School Service Commission and West Bengal Board of Secondary Education. Stop. উপরে affidavit service টা করে। Stop. In spite of service of notice, state respondents are not represented. Next one. Petitioner prays for transfer on medical ground based on an application dated on application preferred in prescribed for pro forma, and the school authority has issued no objection on 27th April 2025. Stop. 7th April 2025. Stop. It is submitted that petitioner is suffering from it is submitted that concerned district inspector of schools AC कुछ भी yes why the Kuchbihar matter is here Yes,
Transfer matter.
Kuchbihar.
Transfer matter.
But I have to give direction upon the DI Kuchbihar.
Yes, but my lord can direct it because of that, my lord.
Petitioner is also staying at Kuchbihar. Come to page 1.
School is there, Kuchbihar, yes.
Then it has to be before the circuit bench.
Greatest of that, that's this, my lord, greatest of this, that ought not to be. Because of that, my lord, 226 provision is that if a part of cause of action arose, my lord,
Petitioner is staying at Kuchbihar. DI is at Kuchbihar, and this court has to give direction upon the DI Kuchbihar.
on the basis of the my lord, transfer.
Issue.
My lord, their party is also, my lord, kindly.
On perusal of the on perusal of the
My lord,
writ petition,
kindly
it appears-
see the
on
address, my
perusal
lord.
of the writ petition, it appears that petitioner is staying at Kuchbihar. Petitioner is staying at Kuchbihar, and petitioner has grievance against District Inspector of Schools, AC, District Inspector of Schools, AC Kuchbihar. Since said District Inspector of Schools is not taking steps based on transfer application made by the petitioner. Stop. Next. Issue comes under the jurisdiction of issue comes under the jurisdiction of circuit bench at Jalpaiguri of Calcutta High Court. Now, circuit bench at Jalpaiguri of this court, or comes under the jurisdiction of circuit bench at Jalpaiguri. Stop. Next. Let the matter be immediately transmitted to the circuit bench at Jalpaiguri by the registry, and the writ petition to be renumbered, renumbered, and to be placed before the bench, and to be placed before the appropriate bench for early hearing.
Of all the reference, SSC is also party as well as state is also party.
We also missed out because
My
it is
lord,
Kolkata. That is
but
why
part of cause of action if arose, the part of cause of action on SSC and state is party there. If my lord,
Go take a break, go to North Bengal, good weather is there. The matter. Yes.
Item number 15.
But for the petitioner, my lord, in this matter, CPF to GPF area pension interest matter. Before the division.
State.
Third sub. Third sub, my lord.
Yes.
My plan, kindly let this matter inclusion in the next monthly, September monthly. In the,
Oh, you are seeking interest on area pension.
yes, madam. Well, this matter pending before the division bench.
Whether the issue has been considered by the
Considered this week 14, my lord, fix this matter, my lord. That will be considered. On the ground, I am paying
as prayed for on behalf of the issue. Learned advocate representing the petitioner submits that the issue is pending before the honorable division bench in connection with other matters. Stop. Stop and accommodation is prayed for. Stop. List the matters under the heading motion in the monthly combined stop. September 20. Next.
with me, my lord.
Next. Yes, evidence service, file or evidence service?
No, not the next I'll file, my lord.
Next.
Next one.
Item number 16.
Same, my lord.
Interest on area pension.
Yes, sir.
A same order. Yes, next.
Item number 17.
Same matter, my lord.
I am for the state, my lord.
Better let it be in the monthly list of October. Because today we are in the 11th of August. It
Yes,
takes
yes,
some
sir.
a monthly list of October.
Yes, sir. Yes, my lord.
Same order. Monthly list of October. Next.
Item number 18.
Lord, I am for the state authority.
You are for the state.
Yes.
Give your appearance, same order, monthly list of October. Issue is pending before the honorable division bench. Yes, next.
Item number 19.
Same matter, my lord.
Interest on area
Area
pension.
pension.
Same order, monthly list of October.
Item number 20.
Same matter.
I am for state.
Interest on area pension.
Yes, sir.
Same order, monthly list of October.
22 also same matter, my lord.
Your lordship, there is a report from DI.
It's not required at this stage.
22 also. my lord.
Come back.
Yeah.
Yes, call the
Item number 21.
Item 51, my lord, I am appearing for the petition.
Yes.
The ability of service fund. Petitioner is registered to get the family pension, the widow daughter. Now the petitioner's father was died in blood pre-81. After that, mother has received this family pension. And after death of my mother, I have already applied, but due to the my lord, litigations of this honorable court, but ultimately Sobitara's judgment has already been affirmed by the apex, larger bench. Special court.
But the larger bench decision, there was a benefit of DCRB scheme 1981 was extended
Yes.
by way of granting family pension in favor of widow, divorced,
and unmarried daughter.
and widow daughter, divorced daughter, and unmarried daughter. But here, petitioner's father received pension in terms of 2010 circular. Now, if it is not under 1981 DCRB scheme, then how you will get the benefit of DCRB's that judgment? Because here father received the pension in terms of 1st of October 2010 circular. So if that is so, then therefore in 2010 circular advice to the extent of family pension can be extended to the wife or
Unmarried daughter or widow. Or
no, up to the extent of wife. If pension is not sanctioned in favor of DCRB scheme 1981, if pension is sanctioned, finding that the pensioner is entitled to pensioner was pre-1st of April 1981 employee or teacher who died or retired pre-1st of April 1981. In that event, your pension was not sanctioned in terms of DCRB scheme 1981, dated 15th March 1985. If that is the situation, then special bench directed in interpreting DCRB scheme DCRB scheme dated 15th March 1985 that family pension can also be extended to daughter, unmarried widow or divorced daughter. But that benefit is not extended in terms of 1st of October 2010.
But in the matter, it has already been issued the PPO. Pension payment order has already.
Yes.
Pension payment order has already been issued.
In whose favor?
But in favor of the petitioner. Only this is the matters in regard to the area pension. Interest. Only interest to the area pension.
Pension has been issued in favor of?
In favor of the petitioner. But I already annexed this PPO.
Show me the PPO.
That's 42, page 42. So the petitioner is Kavita Sinha.
Where is the name of the petitioner? It is late Mrigango Shekhar Ghosh.
This is the father.
Yes, father.
This is
What is the name of the petitioner?
Kavita Sinha.
Yes. Where is Kavita Sinha?
Kavita Sinha is the
yes, where it is written?
Kavita Sinha appeared and identified.
Where?
Bottom. Name appeared and identified. Kavita Sinha. Okay, Diganko relation daughter, widow. Serial 8, family pension, relation daughter, widow.
Oh, already pension payment order has been issued.
Yes, yes.
Now, what you are paying for interest on what now?
Area.
Why?
But the amount of pension and family pension will be released on 3rd April 2024.
21st
3rd April.
This is dated 21st March 2024.
21st March.
PPO is dated 21st March 2024.
My lord.
Yes.
Amount has been released on 3rd April 2024.
3rd April 2024.
My lord. Area pensions was released.
Twenty-first March 2024 to 3rd April 2024. How many days delay?
I don't know. But at 9th December 2019, this honorable court was passed an order. And thereafter, my lord, the honorable larger bench passed this judgment on 20th June 2023. No. 'Markandeya Kanchi'.
Now, when you have deposited the documents, including monthly pension, taking into consideration petitioner's monthly income.
In terms of the, my lord, the High Court.
This judgment was delivered by the coordinate bench on 9 December 2019. Now, within 8 weeks, it was directed to complete the court directed to complete the process.
My lord.
The respondents. Now, when you deposited this, submitted these documents, taking into consideration petitioner's monthly income and other relevant circumstances. So, therefore, legal year certificate and monthly income certificate when deposited before the DI.
Within 15 days.
Where you have stated?
It was not averment. That was not averment. But ultimately, my lord,
How could we come to the conclusion?
But ultimately, it has been.
You are seeking interest based on this judgment of the coordinate bench dated 9 December 2019.
Yes.
Court directed by 8 weeks to complete. Now, if court finds, now you are praying for interest due to delayed payment of pension on arrear pension.
No, initially no pensions was granted. No sanction was granted.
Now it was
pursuant to my application in 2009.
Here this court, 9 December 2019, court directed complete the process by 8 weeks, by 8 weeks, complete by 8 weeks. That means 2 months. and taking into consideration petitioner's monthly income and other relevant circumstances as the case may. Now we all know that in case of family pension to be extended in favor of widow daughter or divorced daughter, then what two most important documents are income certificate to be issued by the BDO and legal heir certificate.
But this is
When these documents were considered submitted,
this issue is not melted at this present stage.
yes,
Even
yes,
appeal was
taking into consideration the petitioner's monthly income
then melted
and other relevant circumstances.
a division ballot pursuant to the order ballot in the writ petitions that was ballot preferred an appeal. That
you preferred appeal?
No, the state.
Yes.
After having disposal of my case, ballot preferred an then larger bench was ballot.
Larger bench is in a different respect. You are not party before the larger bench.
Particularly, this Kavita Sinha is also made a party in these proceedings.
Before the larger bench?
Yes. Sobita Rai along with the Kavita Sinha.
Yes.
The petitioner is also. Now, ultimately, the larger bench judgment has been challenged by the state before the SLP. Now, SLP was also dismissed. So, this order has been confirmed. So,
so that has been, so therefore, the pension has been paid to you in terms of the decision of the larger bench.
That's why I am saying that.
Now, where is the question of interest? Today, court is considering the interest. Now, in determining your right to get interest, it has to be considered whether delay is attributable to the state or not.
Yes, yes.
Now, state preferred an appeal.
My lord.
Ultimately, it was decided by the larger bench when?
The larger bench was judgment delivered on, my lord. That is 20th June 2023.
23 against that SLP was preferred.
Yes.
When SLP was dismissed.
12th.
Show me the judgment order of the Honorable Supreme Court in SLP.
No.
Do you have the copy of the order?
No, at this stage not.
Bring it that order.
I will definitely I will. But so far this the judgment this PP has been issued.
Yes, but where is the delay? Because state preferred appeal right up to Supreme Court. Then Supreme Court dismissed the appeal preferred against the judgment delivered by the Honorable Division.
I am
special bench.
But I am praying in regarding this interest on and from after received this amount. When I received on 3rd April 2024. When
yes, you received on 3rd of April 2024. You received this amount.
Yes.
Now, this interest, this pension payment order was issued on 21st of March 2024. And it was received by you on 3rd of April 2024. So where is the delay?
Delay that means so for this amount of that pension I have already received. But so for the area, that area when the ballot I am entitled, but during the litigations of this honorable court, the matter is going on.
But have you received area?
But
have you received area?
Yes. 3rd April 2024, I have received the area.
So pension payment order was issued on 21st March 2024.
Yes.
And within a period of 20 days.
20 days.
For 12 days, this area was released. So where is the delay? Pension interest will be accrued in your favor in case it is found that there is a delay. Where is the delay?
Delay is 9th December 2019. When the honorable court was order passed.
Yes, that's why taking a cue from the observation made by the by the coordinate bench in the judgment dated 9 December 2019, I am asking you when this last pay certificate, when this legal year certificate and income certificate were produced before the delay.
There is no any requirement of the authority.
Come to page 11, page 41, internal page 11 of this order. Come to page 41.
Copy down. The petitioner's
paragraph 10, last four lines. Taking into consideration petitioner's monthly income and other relevant circumstances as the case may be. So for getting family pension, income certificate and legal aid certificates are necessary.
Yes.
When these documents were submitted.
That was not annexed, my lord. My leave may be granted, but to file a supplementary.
That is
affidavit.
what the court is asking you.
All right, all right. But so far this area pension is concerned, so the PPU has been issued, we received the amount.
It has to be find out
My lord, my lord.
whether the delay is attributable to the delay is caused due to state or there was delay on the part of the petitioner in submitting those documents.
Because each and every my lord, sentence of the larger bench.
Affidavit of service filed on behalf of the petitioner is taken on record stop. And advocate representing the petitioner prays for leave to file a supplementary affidavit disclosing when last pay, when income certificate and legal aid certificate which were issued by the competent authorities were submitted before the pension sanctioning authorities
for the state
in terms of the judgment of the coordinate bench dated 9 December 20. Did such supplementary affidavit be filed by 10 days from date with an advance copy upon the learned advocate representing the state respondent. This is the matter under the same heading on 2nd September 2024. Next.
Item number 22.
Yes. 20 এই শোনো অনেকগুলো ম্যাটার একই রণবীর নিয়েছে মান্থলি লিস্ট অফ অক্টোবরে আসবে এটা থেকে সেম আর আরেকটা জিনিস শোনো তুমি monthly list of
Item number 23.
call for counseling. Call for counseling. Did not appear in the process. Call for counseling. Yes. For when you have called for counseling? One of November 2024 at page 57. I was very disappointed. Following Mukti, my lord, your lordship was Mukti Vishal.
But there is no representation from the petitioner till date that I want to participate, just the writ petition. No representation. No, if we identify, we will point it out. Allow special circumstances or
Verification of testimony.
and availability of vacancies.
Verification of
So that Mukti does not mention.
But it's subsequent orders based on the submission I have.
Very
These orders recorded. Just yes, Mr. Dasgupta appeared for this. As it appears.
Thing is, the division bench is also looking into the matter, and the division bench is keeping is directing us to give the updated data, and we have given the exact figures of candidates who are not yet included. Excluding these candidates. We have not included these candidates in our data.
What can be done? Petitioner has lost job. Otherwise, petitioner would have participated in the
That is
situation also. The Honorable Supreme Court directed by creating supernumerary
that is
government employees.
That is for those who were in service.
For state government, not government employees. So who leaving those jobs join the post.
Yes, in service, but not
So therefore,
Supreme Court showed no mercy for these candidates. That mercy they are getting over here.
some mercy to these teachers. who have-
That mercy they are getting over
and
here.
attended teachers, those who are working, they should be given a chance to participate.
They could have participated. That was not in the way. They were hoping for the best.
Enter into these niceties because there are several petitions coming that they are not permitted to participate since they are working.
But if I have issued a
And it was your submission also, Mr. Dr.
yes, that is true. But again, side by side, many we have called and given also.
Signed it. Have you enclosed the merit list after percentage? Which bill?
Page 57.
57.
There are multiple ranking. I am showing only one 56.
Serial number 101. Yes, first.
Finish.
Yes, same order disposed. I'm telling you.
Item number 24.
There are two orders. In the method, initially was passing a protocol affidavits, but thereafter
Your lordship is dismissing. The issue is the petitioners did not participate in the interview. Now they want definitely thing under. There are instances your lordship is passing an order. We are coming before your lordship is rejecting our claim, but subsequently the authorities are allowing. For example, my lord, the extension of last. What is happening? On these petitions are being dismissed. They are facing difficulty. My lord, I am very candid. Your lordship, there is a chance, my lord. Since there are eight candidates and vacancies are more in the upper primary, there is a chance consolation. All these candidates are regularly visiting, calling the chairman. Some of them have told me, my lord, that there is a chance that if there are vacancies remain, it may take up to the government considering their special situation. But I would request your lordship kindly to go out of list or epidemic dismissal. Ultimately, if they take a decision, then a dismissal order, my lord, will
No, Mr. Dasgupta. You did not participate in the interview in 2021, 2022. What will happen ultimately? Decision is taken. That cannot be recorded here.
Yes,
in the judicial order.
Definitely.
Where is the order?
Single order, my lord, I am not fasting. Probably Mr. Chaudhary's matter.
Mr. Chaudhary's first matter, Mr. Mujumdar appears.
Somu Mujumdar.
2021, 2022 interview did not participate. Today, if I have recorded in my notes, if the contention of the petitioner is accepted, now the direction has to be given for holding interview again. That is not permissible at this stage. Nine and 10. Your mark was above the cutoff.
I am making my lord. Even if there is no interview, I will.
Whether you participated or you are not allowed to.
I was participating in the selection process.
No. Whether you are not allowed to participate in the personal test or not.
No, it was that
You did not participate since you are working.
Yes, no, I was in service. I am initially, my lord, they were not allowing us to give the interview. This is a fact. I did not thereafter approach the court to allow us to see.
But whether what is the case made out in the petition?
Yes,
whether you did not participate in the partial test or you are not allowed.
I did not participate. I'm extremely sorry, my lord. Paragraph.
Who is for the state? We are for the state.
Item number 25.
Is my application, my lord. Kindly consider, my lord, I am praying for accommodation for this day, my lord. This is my application, my lord.
Where is the service support?
Yes, sir. I have served for this.
I'm Mr. Subhaprakash Ladi applying for the state mile. Subhaprakash Ladi mile applying for the state mile. He's on legs mile.
Tomorrow, my lord. My lord, matter. Disbursement of pension, my lord. A petitioner was the assistant teacher in a junior high school, my lord. My lord, in the year joined 89 and retired 31st January, my lord, 24, my lord. My lord, the TDA, my lord, 24, my lord. The after retirement of his service, my lord, petitioner made several presentations to the school authority, my lord, drawing and disbursing officer, my lord. He raised an objection so many, and lastly referred the matter to the Commissioner of School Education. And matter is now pending before the Commissioner of School Education, my lord. Commissioner of School Education, kindly see last.
How the matter was referred to the Commissioner of School.
My lord, kindly see page 61 for a moment, my lord. Page 61, column number 15. Well, if there is objection made by the DDA, my lord, let the matter be referred to the Education Department, Government of West Bengal for further clarification. And same was also column number 15, my lord.
Now, higher scale of pay was sanctioned to you.
Yes, my lord.
How?
My lord, kindly see page, my lord. Initially, that was dismissed by the DIF school, my lord. Refused by the DIF school. Thereafter, again, on the basis of government circular, my lord, the DI allowed my prayer, my lord. Kindly see page. Page 39, my lord.
No, it's not an awarding of higher scale of pay.
My
Can
lord.
be considered.
My lord, next, my lord, page 45.
Not a memo whereby you were giving procedural scale of pay.
My lord, thereafter, kindly see page 45, my lord. The DI
Whether it has been
allowed my
sanctioned,
prayer.
yes or no.
Kindly see page 45, my lord.
I am asking you whether it has been sanctioned in your favor or not.
Sanction, my lord.
How? How?
Well, on the
The document which you are drawing attention of this court is not sanctioning menu.
My lord, kindly see page 45, my lord, for a moment, kindly.
Yes, page 45.
45, order of DI, my lord.
That is in terms of the court. Order of the court.
Not by the court, my lord.
Yes. WPA 16643.
No order was passed in that particular period of time, my lord.
Show me that postgraduate scale of pay was sanctioned to you. Show me.
Well, kindly give me some time
Why?
so that I shall satisfy you. Kindly take it.
File far back on 1st of July.
Well, excuse me. I shall satisfy your lordship kindly day after tomorrow, my lord. I shall satisfy you, my lord. Day after tomorrow, kindly consider.
No, not according to your sweet will. Sorry. Show me it has been sanctioned. How it has been sanctioned.
Well, kindly see so many replies are there by the school authority and the DI, my lord. Thereafter, the matter has been referred to the school education department.
Matter is heard in presence of the learned advocate representing the petitioner. However, on posing certain queries, learned advocate has prayed for accommodation. So, this is the matter under the heading motion in the monthly combined list of September 2021. Next.
Item number 26.
Lord, I am for the school authority respondent number 5.
Yes.
Service third course use.
Litigation. Previously, your lordship passed an order respect of my transfer application to consider the same which was pending before the school service commission. But that order I have annexed page 20. Pursuant to the strength of my lord's order, school service commission recommended me. Your lordship passed order on 22nd of January 2025. School service commission recommended me for transfer, which is on 7th of April 2020, which is in page number 23. In the page number 23, 7th April 2025.
Proceeding pending.
Strength of my lord, strength of recommendation, board issued the transfer order that is in page 24, but which is issued on 22nd of May 2025. I have been directed to join in new school within 5 working days after getting the release order from the school. Now difficulties arise when I am making an application for release of school authority. School authority raised some question that some discrepancies arises in regarding midday meal. What are that school authority?
Where you are working?
Where I am working.
Proceeding is pending. Board has been, yes, board directed the DI to hold an inquiry and file a report within 15 days.
Kindly.
When it was issued?
It was malad issued on 21st July prior to
1st July?
2025, but prior to show cause notice was issued. And
But there is no charge sheet.
charge sheet
The proceeding starts.
proceeding malad
Summarily, when proceeding
malad 21st July 2024.
in terms of discipline proceedings, when proceeding starts.
Proceeding malad 24th July 2024. He has informed the midday meal was
As per service jurisprudence, discipline proceeding starts from which day?
Malad the board issued the Malad the so-called notice.
Service jurisprudence.
Yes.
Discipline proceedings starts
No.
from which date?
Malad the March 25 so-called notice
Not
was
the
issued.
date of issuance of charge sheet.
Well, now
The charge sheet has been issued.
no. Board directed the DI to hold an inquiry and
Continue for 2
file
years.
to July 2025. And Malad
It has not been issued.
charge sheet has not
He
issued.
is not headmaster of the school.
Headmaster.
Headmaster.
He is the headmaster. And Malad, I have challenged the order of transfer. Malad, I am the president of managing committee. Malad, I have challenged the order of transfer. I filed a writ because the order was obtained behind my back. I have not received any notice in BR's order. Malad, he is the headmaster. Notice was served to the school, but I have not received it. Malad, I have filed a writ petition.
Yes,
Malad,
definitely.
but Malad, I have challenged the writ petition due to appear day after tomorrow. Day after tomorrow, number is 18362 of 2025. Even we, Malad, I have not received that notice prior to Malad the move this writ petition. He is the headmaster. Proceeding is pending.
No proceeding is pending.
No, Malad, here midday meal it was found in the month of August
There
2024.
might have been certain allegations, but
Yes.
criminal.
And kindly see the so-called Malad of the video. Malad, one by the video, he is the releasing also.
Video notice, I am
Yes.
also invited.
To my lord,
My
tell
lord,
him.
video notice stated, my lord.
No, second notice he has not annexed. Second so-called notice.
When
First so-called not Malad the satisfied. Again, second so-called notice was issued by the.
Show me any provision that for issuance of show-cause notice, transfer of the petitioner can be
Correct.
stalled.
My lord is correct, but my lord,
Show me
the
any provision.
board, my lord, hold an inquiry and through DI.
Listen until show-cause notice charge sheet
But
is-
if he transferred,
no pending.
if he transferred large, well, huge amount of misapprehension by the.
Within
If he-
time you have not initiated proceedings.
Within time, well, he has moved. Well, the transfer order he has.
After, I don't know when it has been done, well, after reaching the complaint, what I get from here, would have asked the DI to hold inquiry
Yes.
on 29th July.
No decision has been taken.
Yes, in July,
We'll
just
receive the inquiry report, thereafter show cause, thereafter reply, thereafter.
July, Malad, July, 29th July
What can be
of this
done?
month. No, Malad, the order was obtained. Malad, he knows that 21st July 2024, he was informed that about your conduct. Malad, I have given that, Malad, 24th August 2024. And
Very well, you have filed a writ petition.
I have filed it.
Filed a writ petition.
Malad.
Keep the particulars to my office.
Malad.
My lord, I have not received the copy of that.
I will serve today.
Let
I'll
me
serve.
say,
No, today I will serve to you. 18/362/25. আমিও দিয়ে দেবো হ্যাঁ
file your affidavit of service.
My lord.
Affidavit of service.
ওটার নাম হচ্ছে হাবিবুর রহমান আমি দিয়ে দেবো
Your lordship, kindly notice your lordship notice by earlier order, affidavit of service.
Press for direction upon the.
ডুপি নম্বরটা লিখে দাও।
কোন নম্বরটা
Of Nazirpur Espera High School.
হ্যাঁ নাগপুর এসের পাড়া হাই স্কুল
Eserpara, Nazirpur Eserpara High School.
But only one small submission can I make, lordship?
Murshidabad.
My lord, one small submission can I make?
Not required at this school. Nazirpur Eserpara High School.
বলো না
না, সব চাইছেন নাকি? এমন কিছু তো হচ্ছে। আমি ইচ্ছে করতে কেন কথা বলবো? তো বলেই দিয়েছে।
নাম্বার কেন দিতে বলছে আমরা দিলাম তো
You have not made the school authority as party.
Yes.
স্কুল ইজ পার্টি
After Netaji High School.
My lord, that school I have to
Transfer. Yes, where is Nazirpur
Yes,
Eserpara party?
managing committee, my lord.
Respondent number 5.
Respondent number 5.
School has not made a party, only managing committee.
Managing committee.
Yes. So school, Nazirpur Murshidabad. So school, based on transfer order.
Goodbye.
Board issued transfer order.
Yes.
Where is that?
Yes, my lord, page 24.
Based on transfer order dated 22nd May issued by the Secretary West Bengal Board of Selectors. Next paragraph, Mr. Munwar Ali, Advocate representative. Aforesaid school authority has submitted that a writ petition has been filed, being WPA 1836/2025, challenging transfer order issued by the authorities. Next paragraph, let present writ petition be heard along with WPA 1836/2 of on the next. Stop. Is the matter under the heading under the same heading on 2nd September 20.
Copy of the application.
আমি দেবো রে বাবা, কপি না দিয়ে মামলা হবে, তোমাকে দেবো কেন হারিয়ে পড়েছো? অবশ্যই
এটা টাইপ করবে না?
Today, court passes an order that
Yes, yes, I am clean hand, I have no problem. After my
next.
Item number 27.
Yes.
I'm for the state responders.
What is paid for interest? Interest or area based?
I am covered by my discussion.
Assistant teacher.
And I am beyond group D. This one, the next chart.
When retired?
31st December 2009.
একটা নোট করে দে। হুম ফাইলে যে নাম্বারে ট্যাগ হয়েছে ওই নাম্বারটা।
Date of pension payment order?
Date of pension payment order 25th August 2015. 2015, my God.
এখানে অনেক ছবি দেখা
Let's get Kaushik.
Item number 28.
28 as listed. Thank the clerk.
The peon. Sorry. When retired, 30th April 2010. 30th April 2010. Pension payment order and
July 2015. 15.
লেখা আছে
31st July 2050.
লেখা আছে অন্য না লেখা আছে হ্যাঁ এখানে করবে ঠিক না
We also did.
Supposed to even one.
Grateful Lordship.
All the government. Grateful mind.
Yes.
Item number 318.
Appear on behalf of the original Council of Higher Secondary Education. Yes.
The earlier occasion I had placed the difficulty or not in having the result cancelled. There is a window of 30 days. The regulation provides for this. But the petitioner given the benefit of interchange of marks. And
Please place the facts.
yes, the petitioner appeared in the higher secondary examination in the year 2015. Her mark sheet is at 11, page 11.
Why coming after 9 years?
Because she faced the difficulty, she has to have this result cancelled. She has subsequently passed the higher secondary examination from a different authority, and thereafter she intended to pursue a career in nursing. But there she was precluded from registering herself under the West Bengal Nursing Council, and it turns out that this is because that of her 2 past certificates in HS examination that she is unable to proceed with the online registration. Those
What is the difficulty so far annex? So far page 11 is concerned.
Page 11 has given her the benefit of interchange of marks. If my lord compares this with page 10, if my lord sees page 10 with page 11,
result is passed.
yes,
Yes.
by giving her the benefit of interchange of the optional elective subject with physics in which she has failed.
Bioscience was your optional subject.
That is there in page 10.
In physics, you did not secure qualifying marks.
Yes.
That's why physics was
Interchange.
treated as optional subject and bioscience was treated as subject. Now you are declared qualified. In 2050.
Now, your mind turns to paragraph 6. This difficulty surfaced only after she completed graduation in nursing.
What difficulty? How you are facing? Because we are holding.
This is the online registration.
Where is the other certificate of your higher secondary exam? 19. Really, not 19, Millard. It is. In iOS? Yes. YouTube. 14. Mark sheet at page 30. Now, based on this higher secondary mark sheet, you took admission in a nursing course.
Not West Bengal.
Bangalore. You where? Bangalore.
In Bangalore. She graduated in nursing from Bangalore. But the nursing council.
Obtained this qualification in 2017 from NI base.
Yes.
While she was in Bangalore.
Calcutta probably, but she graduated from Bangalore.
The nursing qualification obtained.
Page 15.
Now, based on your mark sheet, which was issued by NIOS, you can
It is only because of the online registration. She is prevented from logging in. If it had been a physical form that she was required to submit, these difficulties would not have surfaced. Because of that, she faced that
No,
difficulty.
but if it is online, then if you offer your candidature based on your higher secondary pass certificate issued by NIOS,
Apparently,
then how it is detected by the authority?
Because I think something is there in the system which under which her registration number under the High Secondary Council, the system is alerted
Is reflected.
like that. Yes, even if it is not reflected.
Suppose you are holding two degrees or higher secondary pass certificate. One from, as it has happened in the case of Gujarat, one from higher secondary council and another from NIOS. Now, if I disclose your NIOS degree or pass certificate, then it can be detected that
That is the problem. Because earlier cleared the Madhyamik examination, her registration number is there, it proceeded on that basis. And the difficulty she is facing is clearly.
What you are paying?
I'm praying for cancellation of that result.
High Secondary Council's result.
It provided for the regulation provides for that, but with a window of 30 days. The very fairly, I'd say the regulation to take care of such cases, regulation 9.2.
9.2 proviso.
That
It's better than interchange.
the authority is empowered to do that.
Yes, where is that regulation?
9.2 proviso.
Have the headmaster manual of
Regulation 19.
9.2 proviso.
9
2
within
bracket
bracket 2
2
proviso.
proviso.
The converse is not mentioned, that after 30 days, no such application will be entertained.
You have accepted this. This arrangement of interchanging optional and elective.
At that time, this problem did not surface. There was no occasion for the
What
petitioner.
is the stand of the council? Because
Lord, we cannot do it.
they-
Lord. There is a
they think about this, that petitioner has also qualified,
yes.
higher secondary examination conducted by NIUs. Now, based on which petitioner obtained nursing certificate. Now, petitioner is not being found to be an eligible candidate since petitioner did not have bioscience as elective
Yes.
subject.
But
No,
Lord,
because she failed in physics.
Because he failed in physics.
Mathematics was immaterial.
Chemistry, physics and bioscience.
she failed in physics, passed in
That's right.
bioscience.
So therefore, how council is prejudiced?
Lord,
This arrangement.
Lord,
is
regulation does
provided
not
for-
permit us. Regulation does not permit us. That's the difficulty.
It's a regulation
Regular-
that is for the benefit of students.
No, it does not permit us. Lord, if we do it, Lord, then we would be flooded with a Lord,
No. It is not a case of opening floodgate. Seldom it happens.
regulation.
Petitioner already obtained a certificate from higher secondary pass certificate from NIUS. That will be rendered as nugatory in view of the fact that petitioner failed in physics.
She even Lord did not disclose it to that examining authority that she has already passed from her past higher secondary examination from the West Bengal Council of Higher Secondary Education. She didn't disclose it, Lord.
There's no requirement.
While
for
taking
that.
admission in that Lord,
She is required to fill up forms. and
in that
information
organization.
was not sought from.
She didn't Lord. She rather
Now,
consented.
at the time of taking admission in NIUS, had you disclosed it?
No.
As stated, so she was the forms
If
that
you have disclosed it, that
she is required to
you
fill
do
up
not have
forms.
permitted, but why is a candidate is not required to sit for higher secondary examination?
My kindly see paragraph 7. The information that is specifically sought for by way of
Then make NIUS as party. Let me hear the- Because once you have qualified higher secondary examination, then whether any other examining board or any other board will permit you to take further examination,
we have double BS, triple MA.
that is different thing. But it's a basic qualification. You may have obtained on a MA in Bengali. That will not debar you in obtaining MA in English or in mathematics.
But not twice
I
MA.
have come across a teacher, headmaster, who is MA in Bengali and mathematics. That is permissible. But so far the basic qualification in Madhyamik examination or class 10 level examination, class 12 level examination, whether a candidate would be permitted to appear twice from different boards.
There was no need for such disclosure. That is why she filled up the form. She was
NIUS has to be heard that why NIUS permit and whether it is permissible or not. Because if suppression of your qualification of higher secondary examination pass, if you have enrolled with NIUS,
if I was required to supply such information.
Then based on which court cannot pass and pass it on.
If I was required to volunteer
So
such.
that's to satisfy its
I'll
consent.
speak
So what was your conduct, Mr. Chatterjee? Issue.
So this is the regulation of the nursing council, which says that you have to pass in physics. If that
Yeah, there is no quarrel to that. There is no quarrel. Petitioner. The affidavit service filed on behalf of the petitioner. Petitioner passed higher secondary examination conducted by West Bengal Council of Higher Secondary Examination. Conducted by West Bengal Council of Higher Secondary Education. However, petitioner failed in physics, which was hard. compulsory elective subject, which was third compulsory elective subject, but passed in biology, which was petitioner's
Optional.
optional in order to declare the petitioner successful in higher secondary examination in terms of regulation 9(2) of the West Bengal Council of Higher Secondary Education Examination Regulation 2006. Physics was treated as petitioner's optional elective subject, whereas bioscience was treated as petitioner's compulsory elective subject. Thereby, petitioner was declared successful. Next, petitioner participated. Petitioner subsequently participated again in senior secondary school examination within bracket 10+2 held in April 2017, conducted by National Institute of Open Schooling, and she was declared successful. So, based on such certificate issued in favor of the petitioner by based on certificate issued in favor of the petitioner by National Institute of Open Schooling within bracket NIS. Petitioner completed nursing course.
Yes.
What is the name of this course?
It is basic BSc nursing, page 50.
Page 50.
Basic BSc nursing.
Petitioner completed basic BSc nursing course.
Degree.
Nursing degree course. Basic BSc nursing degree course from Bagdevi College of Nursing, Bangalore. And certificate was issued on 24 December 2020. Stop. Now you are not getting job.
I think it is in West Bengal. If she is working elsewhere, but she is unable to register under the West Bengal Nursing Council.
Based on such certificate relating to BSc nursing course and higher secondary pass certificate issued by NIOS, petitioner is unable to register herself with West Bengal Nursing Council. So it is submitted by the line that while registering the petitioner, West Bengal Nursing Council is taking note of higher secondary pass certificate issued by West Bengal Council of Higher Secondary Education. Stop. Petitioner prays for cancellation of higher secondary pass certificate issued by West Bengal Council of Higher Secondary Education. Stop. Next one. West Bengal Council of Higher Secondary Education is represented by Narendra, who has opposed the prayer of the petitioner on the strength of relevant provisions of the West Bengal Council of Higher Secondary Education Examination Regulation 2006 and it is submitted, such regulation does not permit cancellation of cancellation of higher secondary pass certificate issued by council. Next factor, during course of hearing, question crops up whether petitioner, while registering herself with NIOS for participating in higher secondary examination, disclosed her higher
She says she has not.
disclosed her
She has not. She has stated she was not required to disclose.
Lord, one thing, Lord,
She has
he
come
has to, if he,
this court with clean hands.
Lord, if he has to seek, Lord, cancellation, she has to come within 30 days.
That is the
30 days.
difficulty. My lord has appreciated that.
She has to come within 30 days.
But there's no converse, no, that beyond 30 days.
disclosed her higher secondary pass certificate issued by West Bengal Council of Higher Secondary Education. Stop. It is submitted by the right advocate petitioner that previous higher secondary pass certificate issued by West Bengal Council of Higher Secondary Education was not disclosed at the time of registering registering herself by the petitioner with NIOS for participating in examination to get another certificate relating to 10+2 qualification. Stop. Next paragraph. Once a candidate obtains higher secondary pass certificate from one board, same candidate generally is not permitted to participate in 10+2 examination in order to obtain another certificate from another board. Stop. Nothing is produced on behalf of the petitioner to substantiate case made out in this writ petition that petitioner is eligible to participate in different higher secondary examinations conducted by different boards at different point of time. Next slide. Furthermore, West Bengal Council of Higher Secondary Education within bracket examination close bracket regulations 2006 does not provide any provision which permits the petitioner have her higher secondary examination pass certificate cancelled, which was conducted for cancelled, keeping in view of the fact that said examination was held in 2015 and writ petition was filed on 5th February 2015. Purpose of proviso to regulation 9 within bracket 2 is different, and a time is stipulated in the same proviso for not entertaining subjects which are treated as compulsory elective and optionally এটা করবে কি West Bengal Council of Higher Secondary Education Examination. Next one. In view of aforesaid discussion,
I would like to add this. But the only eligibility would be class 10 pass.
No, sir. You have not, if you have suppressed.
That could have been disclosed by way of a requirement. Not could have-
Item number 333.
The last occasion, but we have raised not an issue of maintainability of the writ petition in view of the fact that this is not a DA getting school where the petitioner Milord has been terminated from service in the year 2023. Now this is a consequence of a leave being granted by this honorable court to initiate the proceeding afresh in accordance with the prevalent rules. What has happened was, in terms of the old rules, my lord knows, my lord, 28(8), my lord, of the management rules of proceeding.
That rules is not equivalent to 2018 rules. These DA school are kept outside the ambit of 2018.
Yes. Now, under
It is difficult.
my lord, under the old rules, my lord, a proceeding was initiated. Before it could be, my lord, culminated, my lord, writ petition, my lord, surfaced. Amendment had come into effect.
Where is the scope of
No, my lord. Kindly keep, my lord, the point of maintainability open.
You are representing the school.
I am representing the school. I am sorry, my lord may be surprised.
My lord, your lordship decided this issue, my lord.
I have decided the issue at the interim stage when petitioner approached this court contemporaneously, not termination order. There was an notice for holding inquiry in Priya.
No, there wasn't termination order. It's fine.
That's the order, lordship. Here your lordship decided on the point of maintenance, not on the point of termination. This is the order.
But your lordship, termination order has been quashed and directed to reinstatement. They have preferred an appeal lost. This is the order, and this is the order of the honorable division.
24 FMA
FMA 1075.
টি নেই তো, টি আছে, টি আছে।
Now, where is the order of the division?
সাত পাঁচ পঁচিশ, সাত পাঁচ। Yes. So why is it, where is the exception?
But, kindly sees
The issue has been decided in a similar issue.
the issue is not
If you can substantiate that on following principle of natural justice, this order was passed.
Lord, kindly permit me, my lord, to continue with my objection with regard to the maintainability issue.
That I have decided.
Lord, my lord has, my lord, decided on the issue of amenability, that since the school is a DA getting school, hence it is amenable to writ jurisdiction. I am, my lord, on, my lord, maintainability of the writ petition, assuming that, my lord, it is amenable. My lord, I again, my lord, say that merely because I am a DA getting school, my lord, would not, my lord, bring me within the ambit of, my lord, the 8th March 2018 regulations, which would, my lord, in effect, my lord, give the petitioner an authority to say that his termination is divorce the rules. My lord, kindly sees, my lord, for a moment the definition of, my lord, schools, Lord, as is contained in 8th March 2018, whether, my lord, I come within the ambit of, my lord, those, my lord, definition or not. If I am not, then 8th March 2018 does not govern me. And in view of the fact that Rule 20...
So at this stage, we are at the motion stage.
My lord, my lord.
Now I have taken a decision in Priya Chatterjee.
Lord, Priya Chatterjee...
This is squarely applicable.
Lord, I am...
This is time, your order is stay will remain stay. Unless until you advert to the situation where following the following principle of national justice, you have, if you have passed an order, then your order will not be interfered with. Show me that what steps you have taken before issuing termination.
Lord, I am kindly permit me, Lord, to take, Lord, my submissions in so far as...
Please come to the termination letter.
Lord,
it goes to show that nothing has been followed.
Lord, I am no, it is not.
Only, my lord, one annex chart that is the page 170. Kindly consider page 170. They have issued data recovery of my entire salary, which was paid to me. Kindly see that contact, my
1
170. 170. page 170. Recovery of debt from legal follows an appointment and subsequent. 2023 charge sheet has been issued for all profits of 1993 regarding my appointment. 1993 and 2023 charge sheet has been issued.
What is this? Sir, what? Service to the student is permissible.
Which page, my lord?
170?
One.
Date of birth থেকে টাকা ফেরত দিতে হবে।
This because his appointment is fraudulent.
In 1993, my appointment.
The earlier proceeding was challenged before this honorable court. But he was terminated from service.
The appointment is void. In that event, he has to refund the amount.
That is
The judgment of the recent judgment of the Honorable Supreme Court dated 3rd April 2025 in case of Boishaki Bhattacharya Chatterjee. Appointments of all the teachers were certified. Those who were tainted, they were directed to.
Yes,
those who are not tainted, they are not directed to refund their salary.
A fraudulent appointment, I say, is a tainted appointment.
Where you have stated there is a fraudulent appointment?
The charge sheet.
Charge, page 54. Page 54. Charge number 1.
Best you can terminate it with a refund of under what provisions?
That will be decided. I say I can support. I say I can support. We are at. I say I can support, but I am saying this will be decided on affidavit.
Where is the charge sheet?
That's 54. 54.
Inquiry was held.
Inquiry was held. He was given an opportunity of hearing.
Behind my back.
Kindly see 160.
Kindly see the charge, my lord. In 1993, my appointment was approved by the district instruction schools.
थर्ड डिवीजन एमए थर्ड डिवीजन है
P division.
डी डिवीजन
So in your advertisement, was there any stipulation that the third division candidate cannot apply?
But may I only indicate this that this proceeding is.
And in your second show cause notice, was there any indication that petitioner is required to refund the salary? Because it is a sequel to your order of punishment.
Yes.
Show me in your second show cause notice that proposed punishment was dismissal from service with refund of salary. No. Just a minute, sorry. Show me.
First, may I indicate page
No, no,
76?
please answer the query. Where is,
I,
your, where is your second show cause notice?
I am answering.
Because at the motion stage, court will not go in deep into the matter. Where is your second show cause notice?
I am answering my lord's first query that whether the advertisement stated that.
No, no, my first query is changed. This privilege this court has got.
Yes.
Now you show me that in your second show cause notice, you have indicated this punishment.
Very
That termination with refund of salary.
Yes. The timely.
Where is your second show cause notice?
But there was a hearing at page 164 and thereafter the termination letter is at page.
No, there has to be a second show cause notice intimating that that you are to be terminated from service. Where is that?
My rules will not possibly do not.
Which rules? You have to follow the general rules.
No, no, I'm
I'm
not bound by it.
If you don't have any rules.
No, I have rules. My rules will not do not permit, and the rules of 8 March are not applicable to me. I say they are not applicable to me. Kindly permit me, my lord, to raise this issue. My lord would decide that. I am saying that the writ petition is not maintainable.
But that I have decided at the.
Lord, what my lord has decided, my lord has not considered, Lord, certain things which I intend to indicate. If that was brought to my lord's notice, then my lord would possibly not have passed this order.
These things?
Yes. Now, my lord, kindly.
So first of all, there was no second show cause notice.
There is no second show cause notice.
Whether the inquiry report was supplied to the petitioner?
Yes, and there was a hearing which was conducted, which is at page 160.
Hearing before the inquiry officer?
No, hearing before the. Yeah. 160 is before the inquiry officer and 164 also before the inquiry officer. It was granted opportunity of hearing.
Why you did not participate in the inquiry?
They are participating. Yes, participating. He has submitted the written statement of defense. Everything has been submitted.
No, that is page 164 is the inquiry stage.
Yes.
After inquiry, where is the how this inquiry report was forwarded to the petitioner?
Not forwarded to the
The inquiry report, not after the inquiry report.
So what is the meaning of holding inquiry if the report was not forwarded to the petitioner?
In terms of the inquiry, not the order.
I thought it is post inquiry hearing stage you are indicating. But page 164 goes to show that you are therefore requested to appear at the hearing on the date and time mentioned above and to give against allegation brought against you. And then you are to be allowed to examine and cross-examine. Meaning thereby, this is a notice relating to inquiry.
164 kindly sees.
164 examine and cross-examine.
The last paragraph, if you do not
last but one paragraph, he participated in the inquiry. Now, if it is examination, cross-examination, therefore it's a hearing, it's a notice relating to inquiry. Now, post-inquiry, where is the forwarding of inquiry report to the delinquent?
When he did not turn up on this date, 164.
Even then, you are required to forward it.
That I am under an obligation in terms of.
Without going into this, show me how it was forwarded.
In terms of the 8 March regulations, I am. But if my rules do not provide, the schools of the rule, the bylaws do not provide, then I may not serve him. I may say that your act you have been held guilty. I am terminating you.
Nothing is required.
Then 8 March, if it does not operate,
yes,
then What my lord has held in Priya Chatterjee is because there was an approval which was required. Approval which was required, and my lord has considered Rule 28 sub Rule 8. In view of the fact that these rules have undergone a change, I do not come within the purview of 28A. I come within the purview of 28B. I am an unaided institution. And the definition of unaided institution.
That I have held in Priya Chatterjee. You are not an unaided institution. You are delegating school.
Kindly permit me for a moment to show what do the 8th March rules say, because my lord did not consider. It was not, my lord was not.
It was placed before me.
No,
8 March rules, 18 March rules, where delegating school were kept outside the ambit.
One attempt may I only make to indicate that
No, it is admitted that 18 March rules does not include delegating school.
It does not.
Yes. Is it? Yes. This is the position.
That it does not include the delegating school within the ambit of unaided school.
Then how you are prevented, or why you are not required to follow the old rules?
Because the old rules, yes. Kindly sees that this is the second round of litigation. In the first round of litigation, the division bench passed certain orders. Kindly comes to page 155. Starts at page 149. Now, this is against the writ petitioner herein. He was proceeded against departmentally by the school under the old rules. In the meantime, the 8th March rule came. Our proposed punishment sent to the board was declined. The writ petitioner filed a writ petition challenging, seeking implementation of the order of the board. And we filed a writ petition assailing the order of the board. Both the writ petitions were heard by a learned single judge. Our writ petition was allowed. The writ petitioner's writ petition was dismissed, thereby saying that the board did not had on the date when the order was passed by him any authority in terms of the new rule 8th March 2018 coming into effect. Have I been able to make myself?
Please repeat.
Then, the writ petitioner preferred an appeal.
What was the order passed by the coordinate bench, by the single bench, learned single bench?
The decision of the board declining to approve the decision taken by us was set aside.
That was done after 28 came into force. That is set aside.
The writ petition seeking implementation of the order of the board and thereby compel the school to permit him to join.
Yes.
That was dismissed.
By the learned single judge.
By the learned single judge. We were directed to complete the proceeding.
So the learned single judge direct, if the decision of the board declining to take decision on the proposal forwarded by the school authority, seeking approval of termination, approval of second stage of proceedings, as contemplated under Rule 28. Now, if this was declined, now in that event, what was the necessity? Oh, the petitioner preferred an appeal.
Yes, the learned single judge said that in view of 8th March, now I am under no obligation to take any approval. I am to conclude the proceeding and take a decision and conclude the proceeding. So, we took a decision to terminate him. Now, appeal was preferred by the writ petitioner.
Yes.
In the appeal, now kindly sees that, may I only indicate and then place. But the Honorable Division Bench said that since the proceeding started under the old rules, but could not be led to a logical conclusion, in the meantime, the new rules have come into effect. Neither party can take the benefit on the stage of where the proceeding was left. The school can start in accordance with the new rules. Now, what are the new rules? 8th March 2018 rule says that which brought in 28B, that I have not full superintendence over my teaching and non-teaching staff. I can appoint, I can terminate. I do not require any approval. That fact that I do not require any approval was taken note of by the Honorable Division Bench.
Now, Mr. Chaturvedi, now if court proceeds on the premise that you are not entangled by 20 by the old rules of 1969 management, old provisions of old rules of 1969, also by 2018 March 2018 rules, because March 2018 rules kept delegating school outside the end. Even then you have to follow the general procedure of
Yes.
principle of natural justice. This is now that accepting your stand. Where is the observance of natural justice? Being a delegating school, because in Priya Chatterjee, I have held that, of course, prima facie, I have held that first of all, writ petition is maintainable, and in violation of natural justice, it cannot run.
Lord, may I only
Therefore, you are to show that you following the principles of natural justice, you have terminated the petitioner and demanded refund of salary.
Lord, may Lord kindly seek my Lord's kind attention to my Lord's order in Priya Chatterjee. Lord kindly sees why my Lord held the writ petition to be maintainable. Lord, my Lord.
Now at this stage, I will not go into this issue.
No.
Division bench has not interfered with my order.
No, I'm not on that.
Yes.
No,
so therefore, I will follow my own order.
You,
only to the extent you will be permitted to make submission that how this order of termination and refund of salary was following natural justice.
Yes, Lord, what Lord I'm indicating, kindly hears me, Lord, for a moment. My Lord said the school receives grant in the form of dearness allowances for disbursing of salaries and non-teaching staff. That aspect has also been considered. And why, my Lord?
Your school is a delegating school?
Yes.
At this stage, this is sufficient.
But my Lord has not interfered for that reason. My Lord,
you renounce your deed. I will hold that this petition is not maintained.
Lord, kindly Lord permission. Lord, my Lord has said neither approval has been obtained from the board. Lord, my Lord will not entertain this writ petition.
I am forget about approval. Show me that you have followed the rules, general rules relating to initiation of procedure.
Lord, if approval is
a person who is working from 1993 by a stroke of a pen, you will terminate him without following procedure. That too in connection with the delegating school, that is not permissible.
Lord, I am only beseeching my Lord to consider what did the division bench say.
Are you in a position to answer the query of the court?
Yes,
that you have followed the procedure.
Lord, the procedure that I am entitled to follow, Lord, I have followed, I say.
Yes, in the writ petition,
Lord, the order of termination indicates that.
Termination order dated 24th in the writ petition is heard at length in presence of the learned advocate representing petitioner, school authority, West Bengal Board of Secondary Education and State. Stop. In the writ petition, termination order, termination letter dated 24th September 2023. Issued by the Secretary of Sri Balkrishna Vithalnath Vidyalaya, within bracket, hereinafter referred to as the said school, is questioned.
My Lord is not hearing me on maintainability, my Lord. I am very sorry to say this. I had some submissions, my Lord. I was only indicating that facts in my case and in Priya Chatterjee are different. Kindly hear me on that, my Lord. Passes an order. My Lord is passing an interim order.
By the said impugn termination of by the said impugn termination of the 24th September 2023. Petitioners, 24th September 2023. Petitioner was terminated on the post of assistant teacher of the same school. Learned advocate representing the petitioner. Now, learned advocate representing the parties do not advocates representing the parties do not dispute that the state school is a dearness allowance getting started. Stop. After impugned termination order was issued on 24th September 2023. We did another letter dated 12th December 2023. Secretary of the said school directed the petitioner to refund the remuneration drawn by the petitioner as an assistant teacher from 1993. What is the date of your appointment? 1993.
Date বলছি
August 8, 1993.
From August 1993 being the from 8 August 1993 being the date of petitioner's appointment. Next. Learned advocate representing the petitioner submits in gross violation of principle of natural justice. These two orders, one dated 24th September 2023 and another dated December 2023, issued. We submitted that petitioner participated in the inquiry. You participated in the inquiry. Petitioner participated in the inquiry proceeding, but inquiry report was not submitted, and no second so cause notice was indicating proposed punishment. Proposed punishment of termination and refund of salary from the date of appointment of the stop. Next paragraph, Mr. Piyush Chaturvedi, learned senior advocate representing the state school authority, has opposed the writ petition first on the count that petition is not since the state school is an unaided institution.
No public law element is involved, I say this.
It is also submitted since it is also submitted rules relating to West Bengal rules relating to disciplinary proceedings as introduced by the West Bengal Board of Secondary Education from March 2018 does not or do not apply in case of delegated school. Therefore, the state school authority is free to take steps according to their own rules in relation to initiation of disciplinary proceeding against teaching non-teaching staff of the state teaching in relation to initiating disciplinary proceedings against teaching non-teaching staff, teaching and non-teaching staff. Next one. Petition, court at this stage is considering whether writ petition is maintainable or not, and steps taken by the said school authority while concluding the proceeding against the petitioner is tenable or not. Next slide. There is no dispute that the school in question is in receipt of clearness allowance from the state government. Therefore, the school should not be, or therefore the said school ought not to be termed as unaided institution. Stop. Issue of maintainability of writ petition against a delegating school has already been decided by this court in a writ petition being WPA 12447. Now, on two writ petitions, first one being WPA 12447 of 2022 within bracket Priya Chatterjee versus State of West Bengal and others. Stop. Taking note of the judgment of the Honorable Supreme Court delivered, taking note of the judgment of the Honorable Supreme Court reported in 2022 SCC Online SC 1091 within bracket same Mary's Education Society and another versus Rajendra Prasad Bhargava and others. And another judgment of the Honorable Supreme Court reported in 2014 449 within bracket Marwari Balika Vidyalaya versus Asha Sudhastava and others. It was held that writ petition against a delegating school is made. Stop. Therefore, preliminary point which is urged on behalf of the said school authority is negated, relying upon the ratio of Priya Chatterjee Supra. Stop. Next paragraph on query next paragraph prima facie while assessing the steps taken by the school authority to conclude the disciplinary proceeding against the petitioner, it is not demonstrated that inquiry report was supplied to the petitioner at the end of inquiry proceeding, thereby granting opportunity to the petitioner to offer reply to the inquiry report, to the inquiry report. Stop. Neither second show cause notice was issued by the same school authority indicating proposed punishment of termination and refund of salary from the initial date of appointment of the petitioner in the school as assistant teacher. So it needs to be recorded herein that petitioner was appointed as assistant teacher of the said school on and from 8 August 1993. 1993, 8 August 1993. Stop. Neither any internal rules of the school are produced, neither taken. During course of hearing, no internal rules relating to initiation of disciplinary proceedings against teaching and non-teaching staff of the said school is produced before this court. Therefore, said school authority as it appears was required to follow general rules relating to initiation of disciplinary proceedings against the petitioner, observing principle of maximum justice. Next question. In view of aforesaid discussion, the order dated 12 December 2023, whereby petitioner was asked to refund remuneration drawn by him from the date of his appointment, is still. Stop. However, order of termination dated 11 September 2023 is not interfered with at this stage. Stop. Next paragraph. Party shall be at liberty, respondent shall be at liberty to file affidavit in opposition to this writ petition by 3 weeks, by 4 weeks from date. Stop. Affidavit and reply thereto, if any, we file by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate proceeding. Much time has gone in the meantime. That's why I have not taken the
That's just item number 36 is also either better or either just a different. But since
very late this order, we transcribe saying that can be fast if Mr. Chaturvedi is unable to satisfy the query of the court.
Lord, identical orders, same parties appearing. My lord may pass.
336.
336.
only the date of appointment is different, sir. The date of
No. There also this refunding of remuneration order was passed.
Everything same. Division bench.
36.
So again matter has to be heard. And Mr. Chaturvedi will take another chance.
No, my lord.
Upon this case.
4815.
I was only saying that I could be granted 5 minutes of time any day. When the matter is finally taken up.
আচ্ছা ওইখানে যেখানে ক্রিয়া ক্যাটাগরি না ওখানে একটু ডাউট মিশন কিছু অর্ডারটাকে রেফার করছি এই আগে ফাইলটা দাও দেখো
336, I'm not happy on behalf of the state.
এটা এখন আপনি লিখেন 336
that order of this court passed in Priya Category Supra was tested. This was a honorable fiction test. By But the sale order.
আমি স্টেট না বাস করতে আছে সুশীল কুমার রায় তো
Within bracket, Balika Shikha Shodhan and another, Balika Shikha Shodhan versus the state of Uttarakhand. But so order passed by this court is clear that Shukla was not.
Item number 336.
Only one submission you have made me, my lord, present on record. I say impugned action relates to no public law element. But this is my specific sum. Kindly not record this so that it would be known that I have raised this issue. I'm not as much on maintainability. I say impugned action relates
So
to.
what does it mean, Mr. Chaturvedi? That a school is, I have stated that your contention that the school is a self-financed school, is a private school.
Yes, which maintainability. Where I am not.
Acha, ওইখানটা একটা পড়ো।
Thank you.
Now, since the said school is under institution and no public public law element is attached there. Attached there.
আমি স্কুলের না
Now, what element is attached here? Is called the next matter.
66 I am for the state respondent.
Yes. Where is the termination order?
Only the date of appointment is different and all are.
Show me the termination order. And tell me the date of appointment. You are appealing for the school of.
Date of appointment is July 16, 1997.
Termination letter 146 page man.
Just July
16, 1997. Date of appointment.
এটা অর্ডার আছে
And termination later is at page 164 dated
164.
164 dated September 24, 2020. These are all.
তো দুটোই আছে
And recovery of salaries at
164 dated 24th September 2023.
yes, yes.
And recovery order
Recovery is at page 147 dated December 12, 2020.
147.
147.
yeah 146 order is there the termination letter
You are for the state.
lordship
Taken. Thank you all. Appointment letter 16 July 1997. 8 August 1997. 1997. Termination order December 2023. 12 December 2023. Wait, no, sorry. Termination order is 24th September 24th September 2020 and recovery order 12 December 20. Same. Order.
deployed
Yes.
item number 334
334 I am for the petitioner, my lord. I am for the state, my lord. This is, my lord, the second round of litigation, very innocuous prayer, my lord. Despite my lord sanction of my 2-month arrear salary, that has not been paid, my lord. Previously, I have filed a writ petition. My lord, I have not retired, my lord.
Arrear salary for which period?
My lord, only for 2 months, my lord, that is January and February 2030. From my erstwhile school. From my erstwhile school. But page 25 is the order, my lord.
February 2030.
30.
Why actual school? You have left the school and joined another school.
Yes, my lord.
Transfer or on a.
No, on transfer or
So this January, February 2013 salary was not paid.
not paid.
Why it was not paid?
My lord, it was withheld, my lord. Kindly takes up page 25, my lord. The previous,
Whether the bill was submitted by the erstwhile school authority.
my lord, as per the last order, my lord, it is stating, my lord, it has already been sanctioned. Line,
Where is that order?
my lord, page 25, my lord, my order passed in my previous writ petition.
Who is appealing for the state? You are not led by anybody.
I'm led by Mr.
Where is it?
May I please?
This order of this court is you are relying upon.
Yes.
Just leave it. Where is your notice? Where is your notice?
I beg your lordship's pardon, my lord. If
All parties are.
yes,
Affidavit service filed on behalf of the petitioner is taken on record stock. Or respondent, except in state respondents, other respondents are not in record stock. Guard access to the petition and serve notice upon the upon non-affidavit respondents or the learned advocates represent those respondents, enclosing copy of this order by changes from date and file further affidavit service of these. This the matter of the same date in the monthly combined list of September 2020. Next.
Item number 335.
That I want to object to this. That they have no authority to file this application. That this is my affidavit of service. That I'm questioning the propriety of the order passed by the Commissioner of School Education, which has been passed, but in terms of the order of a division bench. Now, but I was the headmaster of the school, first school, but from 2019 to 2022. But in 2022, I have hand over the charge. On 17th, I have hand over the charge. The last pay certificate and the other documents was given to me. And when I joined the next school on 18th of February 2022. Now the difficulty is some of the as headmaster. Now, some of the interested parties, I don't know who are they, they approach the court of the Honorable Chief Justice in a public interest litigation. In a public interest litigation, they said that the audit was not done during my period. In the previous school.
You have joined the second school.
Second school. In the previous school, when I hand over the charge to the TIC, all the documents were verified, including the presence of the DI. Now, no liability certificate was also given. Now, I am discharging my duty as a headmaster. In the previous school also, I was the headmaster. Now, they approached the division bench in a public interest litigation, mentioning that they are the guardians and some of the persons are ex-member of the earlier school of the managing committee. They are not the present members. In that petition, the order was passed directing the commissioner to pass a reasoned order. Now, kindly see.
Come back to me. Take it back to file.
Priya Chatterjee also, I have given to your lordship.
Yes.